Maalab na pagbati, Pilipinas.
Makasaysayan ang araw na ito. For many advocates of human rights and civil liberties, today marks a highlight in the tug and pull over Philippine democracy. Ididinig ngayong araw ng Korte Suprema ang Anti-Terrorism Act of 2020 o Republic Act number 11479. Isa ito sa pinaka-controversial at highly contested na batas sa mga nagdaang taon. Oral arguments ang tawag dito. Kumbaga, face-off ng mga abogado ng gobyernong Duterte na siyang pumasa nitong batas na ang tawag ng marami ay terror law dahil di umano maghahatik ito ng lagim hindi sa mga terorista kundi sa mamamayan. 37 ang petitions na inihapag sa Supreme Court para questioning ang anti-terrorism law. At pinili ng petitioners ang 13 legal counsel bilang kinatawan nila sa oral arguments. Ito ang mga abogadong haharap sa Supreme Court Justices para ihain ang mga argumento kung bakit dapat ibasura ang batas dahil sa paglabag nito sa konstitusyon. Para sa depensa naman, sa kabilang panig, si Solicitor General Jose Calida at ang mga abogado ng opisina niya ang haharap. Ilang beses na nag-attempt si Calida na humingi sa Korte Suprema ng cancellation of legal arguments. Marami siyang dahilan, humingi din siya ng postponement kasi nagka-COVID ang staff niya. Last week ang huling effort niya na may kakaibang dahilan. May psychological trauma daw siya dahil sa COVID-19. Nagtaas ang kilay ng mga justices at hindi pinayagan ang effort ng cancellation ni Calida. Oo nga naman, kung lahat tayo parang si Calida, paralisado na sana ang bansa. So bakit may ganitong batas? Tinulak ni Duterte ang bagong batas para daw masugpo, mapagbawalan ang terorismo at maparusahan ang terrorism suspects. Ang sabi nga ng human rights advocates in those 37 petitions, the provisions of the law actually attacks legal dissent and legal activists more than terrorism and terrorists. And they add, like the bloody drug war of the last 4 years, the new law sweeps away and tramples on the constitutional mandate that grants everyone due process. Sa simpleng salita, tabingi daw ang scales ni Lady Justice dito. Imbis na gobyerno ang may obligasyon magpatunay ng mga paratang o mag-ipon man lang muna ng sapat ng ebidensya, pwede na ngayon magtapon ng kung ano-anong hocus-pocus at pick-upin at ikulong ang isang tao na halos walang rekurso sa mga abogado o sa husgado. Pwede ding ma-freeze ang pera at ari-arian mo at walang kaabog-abog. At problema mo ang magpakita ng pruweba na hindi ka terorista. We leave the details to the legal experts, but for now, samahan nyo kami para ihatid ang updates and analysis sa ginagawang oral arguments kayong araw. Ako si Inday Espina Barona.
At ako po si Edge Uyangoren live dito sa studio ng AlterMidya.
At ito
ang AlterMidya special coverage.
Edge, go ahead.
Magandang hapon sa iyo, Inday. Kaabang-abang ang mangyayari ngayong hapon, no? I believe magsisimula na ang oral arguments sa Supreme Court at handa na ang lahat para bantayan itong mga pangyayaring ito.
And Edge, I understand may mga tao sa labas ng Korte Suprema ngayon?
Kaninang umaga ay nagsimula ng alas 9 itong mga pagkilos, no, sa labas ng Padre Faura. Nagtapos ito ng alas 12 ng tanghali, pero pag alis namin, Inday, nandun pa rin yung ilan nating mga civil society groups para mag-abang.
And I'm sure nakatutok, maraming tao ngayon na meron rin live stream ang Korte Suprema, of course, and you will also be watching that here on AlterMidya.
That's right. At ang paalala nga ni Attorney Chrissy Conti kanina, kung may mga hindi kayo maintindihang terms along the way, may mga Latin nating maririnig, i-text nyo po kami.
Of course, we will try, no, i-explica rin natin, pero bagamat hindi rin tayo abogado, but still, merong mga bagay na pwedeng ma-explain natin sa mas madaling paraan. And guess
At yes,
natin
Inday,
ngayon,
kasama rin natin mamaya ang mga lawyers.
Okay, so 37 petitions, no? Tinitingnan ng mundo actually ang Pilipinas ngayon, no? Because while other countries also have their anti-terrorism law, mukhang ibang level ang pinasa ng Pilipinas. And naalala mo na one of the main authors, si Senator Ping Lacson, had earlier said, no, na kayo naman, wag kayo masyadong takutin, no, give the government the benefit of the doubt. But remember what happened during the recent red tagging spree? When they called in military officials to the Senate, and it turns out even the senators are now like aghast. Paano kayo nagtatapon ng kung ano-anong mga akusasyon laban sa mga tao na hindi nyo mapanindigan? And yet this, what happened recently, which the senators said, bothered them, are exactly the same things na siguro nasa maraming petisyon na hinaing ngayon sa Korte Suprema.
Under this Honorable Court, Your Honors, we trust in faith for constitution. Thank you.
Supreme Court na yan.
Engages in any of the acts shown on the left column of Exhibit B. The second element occurs when the purpose of such act, by its nature and context, is any of those shown on the right column of Exhibit B. The ATA offers a smorgasbord of acts, intents, and purposes. But what makes the law unpalatable is the fact that it dispenses with the requirements of a predicate crime, which appears to be the norm among nations, and replaces it with acts intended to cause death, etc. Since intent is generally inferred from a person's acts, the law gives state agents the power to arrest any citizen based on their subjective impression of their intent. Worse, it allows the state to simply presume the existence of intent from the citizens' acts, even if the acts themselves do not constitute a crime. Anyone, therefore, who tweets for people to attend a peaceful rally could be arrested for engaging in acts intended to endanger a person's life due to the danger of COVID infection. That is Exhibit C. Anyone who posts on Facebook for the people to boycott a digital services company owned by someone close to the president or who engages in a transport strike could be arrested for engaging in acts intended to cause extensive interference with critical infrastructure, since the term includes telecommunications and transportation. If this law had existed in 1986, Archbishop Cardinal Sin's call for people power would easily qualify as inciting to terrorism. By exhorting the people to gather at EDSA, Cardinal Sin incited them to engage in acts intended to cause extensive interference with critical infrastructure and to endanger people's lives. People power brought Metro Manila to a standstill, disrupted essential public services, and had a debilitating impact on national defense, security, and public safety. Cardinal Sin's call would also qualify as seriously destabilizing fundamental political structure and creating a public emergency. These are but some examples of how the Constitution. In closing, to borrow the words of an esteemed member of this court, quote, rather than a scalpel to precisely remove
Attorney yung nagsasalita ngayon, petitioner na yun, lawyer. Petitioner na yung nagsasalita ngayon sa live. Sinimula na agad. Bilis, no?
Bilis yan.
Sino yun? Sino nagsasalita?
Feeling ko si joke na yun eh. Gahanap ako yung may video, wala pala.
Okay. We're breaking in shortly because to have a few words with Sister Mary Jan Mananzan of the Movement Against Tyranny. Sister Mary Jan, can you hear me? Yes. Okay. I can't hear you though. Can you speak? Okay.
What do you want me to do?
Okay. Hi, sister. No, just a few words. You know, you're a religious sister, and the religious sector has been one of the most badly hit, actually, in the first attacks in the name of the anti-terror law. No, the rural missionaries of the Philippines, especially in Mindanao, has had its bank accounts frozen because
RRM,
of the allegations. Yes, rural missionaries. Okay. Sister, what if the anti-terror law goes ahead? What are the repercussions for not only for the religious organizations but also for the communities that you serve?
Yeah, well, as everybody said already, and I think if somebody has a little intelligence, then they would understand all the objections, our objections to it, saying that actually we see behind this law is really not against the terrorists. I mean, the way we understand it ordinarily, yung mga ISIS, mga ganyan. But what we see there talaga is really wanting to go against dissenters, to go against activists. And for me, the church, has a moral obligation to really say something moral that can have a political repercussion, but in itself is moral, condemning corruption, condemning all what are violations of human rights, all these killings and all that, the church has not only the right, but the duty to do so. Now, if you pass this law, it is as if you are preventing the church from doing its duty. Hindi ba? Kasi hindi na siya makakasalita. When that is its duty, it's not just its right. Mali yung pagkakaintindi dun sa separation of church and state. That has nothing to do with what do you call that, closing the mouth of the church. Actually, separation of church and state is directed to the state. Na wag kayong makialam sa mga freedom of belief of the people. So it's not directed to the church na wag kayong magsalita. Hindi, walang ganon. So ang ibig sabihin nun, itong anti-terrorist law is really going to stop the church from doing what is its duty. And that is to make moral statements on acts that are not really considered ethical and moral. So that is for the church, no? So it is really against our very existence and our obligation. Sa community naman, ang mangyayari niyan, matatakot na lahat ang mga tao na magsalita ng ganito kasi yun na nga, intention na nga lang eh. Parang ano ba sila, meron silang x-ray vision na nakikita nila kung ano yung ini-intend ng isang tao. That is so ridiculous, no? That you are going to be punished for intention. At saka yung act itself, at saka yung intention lang, ay pareho rin ang punishment. Saan ka nakakita ng ganyang patakaran? At saka sino ang magsasabi na may intention sila na mag-harm ng tao, etc. Ang dami nang nagsabi ng ganyan, hindi ko lang maintindihan bakit hindi nila maintindihan. Ang mangyayari niyan, ang mga estudyante natin, ginagawa na nga ngayon, you will discourage them from having critical thinking. Now for me, that is going against not only academic freedom, but against the very essence of education. What is education? It is not just to prepare the students to have a career, but it's really to hone them into critical thinking, that they know how to judge what is right and what is wrong. Now, if they're always in danger of being made terrorists, ano nang mangyayari sa kanilang edukasyon?
Okay. Well put, sister, because like we know that very recently the universities and the academics, have come under fire after the lawyers, sila na ngayon, no? And but see, how would you respond? Because other people are saying really na kung hindi ka naman terorista, hindi ka dapat matakot dito sa anti-terror law na to.
Ano ba yan? Hindi nga terorista ang pinupuntiryan ng law na yan eh. Di ba? Aktivista ako, pero pag sinabing ako'y terorista, hindi ba ako mababahala na yung ginagawa ko na kailangan kong gawin, ako as a sister, ang tingin ko kailangan kong gawin na I will stand up and speak out. That is my essence as a religious. So, kung sasabihin nilang terrorism yon, di wala na akong karapatang magsalita, no? So, talagang anomalous talaga itong law na to. Kasi ang ayaw lang nila talaga, and for me, it's really killing democracy. Kasi if you prevent people from dissenting, if you prevent people from critiquing, if you prevent people from showing what they consider is wrong, anong klaseng demokrasya na to? Walang demokrasya talaga. Talagang fascista na tayong bayan natin.
Okay. I know you're busy and you're going to have a meeting very soon, but just one more question, sister. You mentioned earlier about the obligation of the church, of course, to speak out, on moral issues of our time. And
Yes.
yet we do have some segments of the religious sector that also say, and you're probably better versed in this than I am, that we should bow to authority because the authorities of states come from God. However, I think they quote the Bible, but that's their interpretation of it.
Yeah, I know.
Okay.
Letter to Peter chapter 13. Pinag-usapan na namin ng todo-todo ng mga theologians, no? I mean, you have to see that in the context of the culture and also in the context of history. Not everything that is the Bible should be taken literally. There are certain things like cultural aspect that is not doctrinal. So it comes from the circumstances of the place. Now, between the time of St. Paul and now, there has already been a change in forms of government. Like there is democracy, and there is Nazism, no? Don't tell me any person with his or her right mind would say that Hitler comes from God, that the authority of Hitler comes from God. That is so absurd, you know. So you have to take into context yung sinasabi na you have to obey authority. It depends. Even nga kaming mga madre, meron kaming vow of obedience, but we do not obey blindly, no? So iba
Okay.
ang interpretasyon. You cannot take that literally. In fact, nobody should take anything from the Bible literally. That is the wrong way
Okay.
of reading the Bible.
We should probably have one entire episode on that. But like, just the last question, sister. You were a very young nun, martial law. Now, what? You're a very young looking person in your
83.
80s,
I am 83 years
83,
old.
83, and now you've got the anti-terror law. Um, what do you think? Would you even compare? Is there even a comparison? Um, should somebody who has survived through all that um, be scared of a new law that the government says doesn't exactly translate to actual martial law?
Oh my God. I see. I am really, really, what do you call that, disturbed by this law because hindi pa nga napapairal yan. Hindi pa nga hindi pa nga, so to say, hindi pa nai-implement. Eh, ang dami ng ni Red Scare at pinatay na. Eh, lalo na, kung pumasa yung law na yan, they will always put that law every time they put a red tag over somebody and kills that person. Or they will now cite this anti-terrorist law as the justification of what they are doing. No, it is really disturbing. I mean to say, it is really something that we all people who love their country and their people, we should really fight against this because talagang magkakalat ng lagim. Kaya ang tawag ko nga dyan sa law na yan is state terrorism. Kasi kung ang nagkakalat ng lagim ay the state, o hindi ba sila ang state terrorist? Yun ang tingin ko dyan.
Thank you so much, Sister Mary Jan. Now we're going to go back to the SC where now Nery Colmenares is speaking.
Okay. Hindi marinig.
Innocent when done for as long as the Anti-Terrorism Council, acting as roving lawmakers and star chamber judges, imputes vaguely defined terrorist intentions and purposes on the suspect. After all, who would know what acts are encompassed by a law that penalizes any act intended to endanger another person's life or seriously interfere with critical infrastructure? Worse, the act need not even actually result in endangering a person's life. The mere naked imputation that it intended to endanger a person's life would suffice. The law's peddlers claim that under Section 4, there is a provision that excludes the exercise of civil and political rights from the ambit of terrorism, provided they are not intended to cause serious and physical harm on another person or create a serious risk to public safety. A person exercising a constitutional right through artistic and cultural expressions today would suddenly be committing a crime tomorrow upon the mere imputation by the respondents that such artistic expression was intended to create serious risk to public safety. Clearly, therefore, Your Honors, the mere imputation of intentions and purposes by the respondents suddenly goes into past conduct and transforms acts considered legal and constitutional when done into punishable terrorist acts. The effect of the supposed safeguard, therefore, is to actually expressly provide that said legal and constitutional acts can be considered terrorism on the mere say-so of the authorities of a vague and overbroad law, immediately opening up the law to vulnerability of being a bill of attainder and an ex post facto law. Secondly, Your Honors, RA 11479 inflicts deprivation of rights on a class of suspected persons without judicial trial, when it grants respondents the power to investigate and freeze assets of suspects or cause the detention of suspects for more than 3 days without need for judicial imprimatur. Suspects who are charged in court and granted bail cannot enjoy the benefits of their fundamental right to liberty because their movements and means of communication are restricted under Section 34. Actually, the provisions granting judicial intervention under the law is a mirage. The provision on bailable offenses, for example, for inciting or proposing to commit terrorism, which are punishable by 12 years and therefore bailable, is also an illusion because these acts also constitute the same acts under Section 4, which is penalized with life imprisonment. There is no reason for the ATC, therefore, to file any case for violation of Sections 5 to 12 because all this can easily be prosecuted under the vague, overbroad, and non-bailable offense through terrorism under Section 4. Any one of these intrusions into traditionally recognized areas of protected freedoms clearly amount to punishment within the purview of the Bill of Attainder Clause. Your Honors, in the real world out there, who are the targets of this deprivation of rights? The law targets an ascertainable group of activists and perceived dissenters who have been victims of red tagging and terrorist tagging by the mere claim that they are suspected persons. Based on the action of respondents and contemporaneous events, these suspected persons generally refer to activists or perceived dissenters who criticize or oppose certain government acts or policies. The victims range from churches, international NGOs such as Caritas or the Swedish Red Cross, universities, opposition legislators, human rights defenders, priests, prominent lawyers, and celebrities who are perceived to be opposing actions of public officials who can dish it but cannot take it. Even those who criticize the anti-terror law have become victims of terrorist tagging. Many activists and dissenters, mostly in the provinces, have died while being served by the police with search warrants, many of which were actually issued by judges in Metro Manila on a formulaic narrative of nanlaban. A determination of whether a particular group has been organized for the purpose of engaging in terrorism necessarily involves applying the definition of terrorism to past acts for previous circumstances. Criminalizing membership in designated or proscribed organization likewise amounts to punishment for acts allegedly committed by these organizations or their members prior to the enactment of the law. Section 16 subjects any person to anyone who relates to the suspected person as targets of unrestrained surveillance that allows respondents to collect any private communication using any mode of device on any subject, a clear violation of the constitutional right against unreasonable searches and seizures and the right to privacy. While we consider addressing real terrorism as a legitimate concern, voiding the terror law that overreaches to quell not just terrorism of motley bands, but the dissent of many and the freedoms of multitude does not render the government helpless against terrorists, as there are many laws that can be and are actually being employed against attacks on government and the public. A basic principle
We're back dito po sa studio sa AlterMidya at kasama po natin ngayong hapon ang isa sa mga legal counsel ng isang petition, the 7th petition filed before the Supreme Court para po dito sa CTU HR or Center for Trade Union and Human Rights versus Duterte. Napag-uusapan po natin ang main arguments ng kanilang inihaing petition. Please help me welcome Attorney VJ Topacio. Magandang hapon, Attorney VJ.
Magandang hapon, Edge.
Ang nasasaksihan natin ngayong hapon ay oral arguments na sa Supreme Court. Paliwanag muna natin sa ating mga nakikinig. Ano ibig sabihin ng oral arguments?
Okay, actually, makasaysayan talaga itong nangyayaring to, no? Kasi hindi lagi na nagkakaroon ng ganitong klaseng oral arguments na sa ating pinakamataas na hukuman. Kung di ako nagkakamali, yung huling halos ganito kalaki, no? Yung kaso ng laban dun sa sinasabi nating anti-cybercrime law, no? Yung anti-cybercrime law. At merong 14 petitions na kumontra dito. Pero malayong-malayo sa 37, no, na talagang nagko-question dito sa anti-terror law ngayon.
This was under the Noynoy administration.
Yes, oo, tama yan. No? Pag sinabi mong oral arguments, may mga issues kasi na of transcendental importance na gustong liwanagin, no, ng ating Korte Suprema. Gusto niya marinig yung dalawang panig para madepensahan yung kanilang mga claims dito sa anti-terror law. At ang maganda dito ay mas napapaliwanag sa taong bayan, no, kung ano ba talaga yung sinisigaw ng mamamayan, kung bakit tinututulan yung anti-terror law, at sa panig naman ng gobyerno, may pagkakataon silang i-defend, no, yung batas na yan, although napakahirap ng, ng trabaho nila. Oo.
Sa National Union of People's Lawyers, ang inyong argument ay itong batas na ito, itong anti-terrorism law, RA 11479, ay unconstitutional. Bakit po sinabi ito?
Alam mo, lagi natin naririnig yung term na unconstitutional, no? Pero para sa benefit ng ating mga tagapakinig ngayon, pag sinabi mong unconstitutional, labag ito sa konstitusyon. At yun nga yung binabanggit natin sa petition dito, no? Number one, yung definition mismo ng terorismo, no, sa anti-terror law, sinabi dito na an act that could endanger the lives of the public or any critical structure. Ang mahirap dito, hindi pa, meron din kasing kasama, no, sa batas na yan, yung tinatawag na conspiracy, proposal, at attempt, no, to commit terrorism. Ito, intention pa lang kuno, pwede ka nang maakusahan, di ba, na terorista ka. At ang mahirap dito, hindi korte ang nagde-determine, no, kung terorista ka o hindi, no. Merong mga provisions dito sa batas na sinasabing pwede kang i-arbitrarily detain, di ba, for up to 24 days, from 14 and extendable to 24. Yung sinasabi ni Congressman Attorney Colmenares, no, na yung pagsa-surveillance na up to 6 months, yung walang hintuto, no, na surveillance at walang limits, pag-freeze ng account. So malawak masyado, no, yung binigay na powers, yung executive powers. Linawin natin, no, yung Anti-Terrorism Council na binuo dito sa batas na to ay isang executive na parte, no, ng ating gobyerno. Pero sa sobrang lawak ng binigay na powers sa kanila ay talagang nilaktawan niya na lahat ng mga powers na binigay sa judiciary, at sa lehislatibo mismo, no, na mga equal branches ng estado. So doon pa lang malinaw na unconstitutional na to, at talagang labag na labag nga sa ating mga provisions sa Constitution, particular sa separation of powers, sa presumption of innocence, or sa sinabi nga natin na right against unreasonable searches and seizures, at marami pang iba, no, na yun yung mga kino-question natin sa ating petition.
So, ang main argument ng NUPL dito, kahit hindi pa yung parts ay yung mga parts ng batas, kundi yung mismong batas ang lumalabag sa 1987 Constitution. Tama ba?
Correct. Tama po yan. Actually, ang amin ngang napagkaisahan dito, yung definition pa lang mismo ng terorismo, no, batay dito sa batas na to, ay enough na to invalidate the whole law, no? At yung Korte Suprema naman natin, piniyagan tayo na i-discuss yung iba't ibang mga provision nito na nakikita din naman natin unconstitutional na. Pero yung definition itself, hindi na to makakalusot, no? Meron sa batas tayo, no, yung tinatawag na dalawang principle, yung isang chilling effect, at yung sinasabing void for vagueness, no? Pag sinabi mong chilling effect, ito yung mga batas na pag pinairal mo, ay maaaring magkaroon nga ng chilling effect sa pag-exercise ng karapatan ng tao. Kumbaga, matatakot na sila mag-exercise ng kanilang mga fundamental na karapatan dahil maaari silang maakusahan or masabihan na terorista, no? Yun yung isang tingin natin dito. Pangalawa is yung void for vagueness. Pag sinabi mong ang isang batas ay void for being vague, pag iba't ibang tao, iba't ibang interpretasyon ng batas, void yan, no? na nangyayari ngayon, di ba?
Dapat malinaw.
Yes, sir. Oh, pagka ngayon pa lang, pagsalita ka sa or pag may nagsasalita against sa gobyerno, ire-red tag, tatawaging terorista, NPA, susunod na dyan yung panghaharas, pangdadakip, minsan masama pa, talagang pagpatay. Wala pa yung batas na yan noong nakaraang taon. Pagka nilegitimize mo ngayon yan, naglagay ka ng batas kumbaga, to form a semblance of legality dun sa mga acts na yun, eh, antindi ng senaryo, no, na mai-imagine natin, no, dito sa sinasabi ng ating pagpapairal ng batas na to. Meron ngang isang pari din ako nakausap. Kanina nakausap ko si Sister Mary John, narinig natin, no. Sabi nung pari, maganda naman yan eh, yung anti-terror law, kung puro anghel yung mag-i-implement. Pero hindi ganun eh, di ba? Maging ano tayo, maging makatotohanan tayo na ang dami-dami nang namatay extrajudicially, ang dami-dami ng biktima ng harassment, ng pagsusurveil, illegal surveillance, etc. Tapos maglalagay ka niyan. So, nakakatakot, no, para sa ordinaryong mamamayan pagka napayagan yung batas na yan.
Attorney Topacio, sa tingin mo, bakit ito ipinapatupad? Why are they pushing for this? Sa gitna ng ang daming problema kinakaharap natin, COVID-19, itong disaster. So, why do you think are they pushing for this law at this period of time?
Alam mo, Edge, no, ang dadagdagan ko na lang din bago ko sagutin yung tanong mo. Ang nakakatawa pa nga at mas lalo pang nagre-raise ng question sa akin ay given na meron silang 19 billion na budget, no, yung intelligence, eh bakit kailangan pa ng ganitong batas para palakasin pa kuno yung kanilang pagsupil, no, sa terorismo? Well, ako isa lang masasabi ko diyan, no. Takot ang estado sa dissent. Takot ang estado sa kumu-question, no, sa mga taong mga nag-iisip at nagsasabi na mali ang ginagawa nito. Ang pinakamadaling pang-suppress, no, sa kasaysayan sa punto de vista ng gobyerno ay yung patahimikin at wag na pairalin yung karapatan ng mga mamamayan para makapagsalita. Wala akong ibang makitang lohikal na sagot, no, sa part nila. Kaya nga sabi ko, napakahirap ng position ni Solicitor General para ipagtanggol, no. Ang sasabihin kasi nila dyan, police power. In the exercise of police power, may karapatan kaming gawin to sa mamamayan. Pero may batas tayo, di ba, na ano dyan, na dapat gumagabay dyan. Okay lang naman, sige. Mag-exercise kayo ng police power nyo, protektahan yung mamamayan. Pero hindi pwedeng kayo yung manunupil sa karapatan ng mamamayan. At wala na ako iba nakikitang rason, kundi yung mga binanggit nga natin ngayon.
Attorney, would you walk us through sa process na pagdadaanan ngayong hapon? So kanina narinig natin sa Attorney Menares, no? So ano pa ang mga i-expect natin sa mga viewers natin this afternoon?
Okay, sige, ganito, no. Yung proseso kasi, dahil mahaba yung petisyon, hinati into 45 minutes, no, yung presentation ng bawat panig. So yung petitioners, pag sinabi mong petitioner, sila po yung nagko-question at nagsasabing unconstitutional yung batas. At sa parte naman ng gobyerno, yung respondents, the Republic of the Philippines, sila ay pinapangunahan ng Office of the Solicitor General. Sila yung abogado ng Republikano. Meron din silang 45 minutes para mag-present pabor dun sa batas na yan. Okay? Sa ganitong oral arguments po, may karapatan po ang ating mga justices sa Korte Suprema na mag-interpellate, no? Para sa mga ating mga tagapanood, pag sinabing mag-interpellate, pwede silang anytime na magpumasok at magtanong dun sa nagpe-present para linawin kung ano ba yung posisyon na yan. Okay? Hanggang sa matapos na po lahat ng mga discussions niya at submitted na for resolution itong petition against the anti-terror law.
So how soon will we learn about the decision ng Supreme Court?
Iyan,
Will it be today? Will it that to happen today?
alam mo, Edge, alam mo, ito ang maganda eh. Tingnan niyo yung mga, well, dun sa mga mahilig manood sa mga legal films, ito yung pagkakataon nyo sa mga series sa Netflix, no? To Get Away with Murder, etc. Tingnan niyo yung demeanor ng inyong mga justices. Tignan niyo yung kanilang mga tanong. Tignan niyo yung kanilang mga reaction. Kasi tao lang din naman ang ating mga hukom, no? At siguro dito malalaman niyo na rin in a way kung ano yung mga boto nila. Pero syempre, iba pa rin yan. Magagaling talaga yung mga justices natin. Ngayon, kung gaano katagal, sa experience natin, hindi naman yan madidesisyonan today. I-deliberate pa yan, mag-uusap pa sila, isusulat pa nila yan, no? So, pero sa ganitong klaseng batas, we are hoping na number one, mag-issue agad ng injunction at temporary restraining order para hindi muna kumbaga i-practice itong batas na to in the meantime na wala pang desisyon. Pero hindi natin masasabi talaga kung ano, we can say next week, 2 weeks from now, a month from now, 2 months, hindi natin masasabi
Anything can
talaga.
happen today.
Anything can happen today, maririnig natin at maririnig ng taong bayan kung ano talaga ba yung tama no dito sa posisyon ng dalawang nagbabangayan na mga parties.
Alright, marami pa tayong tanong pero para sa mga tagapanood natin, you can follow the live program of AlterMidya. Ito po yung ating mga social media accounts, no? Facebook.com/AlterMidya, YouTube.com/AlterMidya, and follow us on Twitter/AlterMidya, gayon din sa Facebook.com/Kodaw Productions and Twitter.com/Bulatlat. So, lahat po ng detalye ay atin pong malalaman sa mga pages na ito. Balik muna tayo sa Supreme Court para po sa pagpapatuloy ng oral arguments.
Questions from the court?
Individuals, groups, and organizations opposing a law that will protect our citizens from terrorists. What's their agenda? It's a long posting, Your Honor, but I will now go to his concluding sentences. The day of judgment is upon you. And the Filipino people who have suffered enough from the malignant hands of the CPP, NPA, NDF, of which you are part, of sit in judgment. Very soon, blood debts will be settled. The long arm of the law will catch up on you and your supporters. This is an actual threat, Your Honor. We cannot sit idly by for General Parlade to actualize this threat.
So you would say that this is the actual threat to the safety and liberty of some of the petitioners in this case?
In fact, Your Honor,
How about the other petitioners who have not been charged or prosecuted under the terror law, anti-terror law? Can they maintain their standing to sue in this case?
Your Honor, I will go into that, but General Parlade does not distinguish. He says, Your Honor, let's be watchful of these individuals, groups and organizations opposing a law that will protect our citizens from terrorists.
So we
The
take note,
integrated power of the Philippines, Your Honor,
we take note of that. We take note of that.
Yes, sir.
And we have many readings about it. So in effect, you're saying this is a real threat to the safety and life of the petitioners, or particular some of the petitioners.
yes, Your Honor.
Okay. Thank you. Next question. You are invoking this constitutional duty under the doctrine of the expanded judicial power, alleging that the law gives rise to disputes between co-equal branches of government. Can you enumerate some of these disputes between organs of government to put this case into constitutional context?
Your Honor, under Section 29 of the anti-terror law, the ATC has the power to detain persons for 24 days without warrant. It has arrogated upon itself, Your Honor, the power of the judiciary to issue a warrant. And likewise, it trivializes the rules of court on warrantless arrest. Because in warrantless arrest, Your Honor, it only authorizes arrest on matters which the crime has just been committed, a crime is about to be committed, or a crime is being committed. But in this case, Your Honor, a warrantless arrest is being done without
So
any evidence, Your Honor.
if I may make it short, so it's a clash of the executive power versus the judiciary.
Yes, Your Honor.
Is there any other instance wherein the executive in this case encroaches upon a constitutional organ or a constitutional body,
Your
or
Honor,
even Congress for that matter?
it is also a clash between the legislative uh, branch of government and the executive branch of government, because the legislative branch of government has unduly delegated or delegated to the executive branch of government the power to legislate. And I think in the truest sense, even if both houses of Congress has delegated the rulemaking power, it is still illegal under the Constitution, Your Honor.
So it's not actually a clash, it's just an undue delegation of legislative power. Do I get it right?
Your Honor, unfortunately, the legislative branch of government in this case has abstained its power. But in the truest sense, in the Constitution, Your Honor, it's still a clash between what the legislature can do and what the executive branch can do.
What the legislature can do and what the executive can do or cannot do.
Yes, Your Honor.
Which is which?
What the executive branch cannot do and what the legislative branch can do.
Can do.
I agree, Your Honor.
Thank you. You are mounting a facial challenge of the law. What is the prevailing doctrine on facial challenges of laws like this?
Your Honor, a facial challenge can be mounted if there is a question of unconstitutionality of the law. And likewise, that infringes on the freedom of speech, Your Honor. And, Your Honor, since there is already an actual threat of prosecution by the high-ranking member of the Armed Forces of the Philippines, then a facial challenge is also appropriate.
Of course, we are aware of the decision in the case of Southern Hemisphere,
Yes, Your Honor.
which held that facial invalidation of a statute is allowed only in free speech cases, right?
Yes, Your Honor.
Is there any exception?
Your Honor, Southern Hemisphere likewise cites Holder versus Humanitarian Law Project. It says the pre-enforcement review of criminal statute challenged on vagueness grounds, since plaintiffs face a credible threat of prosecution. In this case, Your Honor, there is already a credible threat of prosecution and should not be required to await and undergo a criminal prosecution as the sole means of seeking relief. So, under the Southern Hemisphere case, Your Honor, decided by this court, then a facial challenge is proper, Your Honor. Although, Your Honor, this topic has been assigned also to Attorney Shell Jock. This is
Anyway, other questions on facial challenges will be given by my esteemed colleague Justice Leonen. Thank you,
Yes.
Attorney Cadiz.
Thank you very much, Your Honor.
Attorney Molo, can we have you on the
Thank
floor?
you very much, Your Honor.
Attorney Molo, are the writs of amparo and writs of habeas data available in this law?
Your Honor,
Can you? I'm sorry.
Excuse me, Attorney Molo, can you remove your?
I think we can remove.
Yeah, so that
Yeah,
we can hear you.
so that
Thank you.
We cannot hear you. In fact, we were not able to hear you clearly when you were speaking earlier. Are the writs of amparo and habeas data available to persons prosecuted prosecuted or incarcerated or suspected of becoming terrorists under this law?
Thank you for the question, Your Honor. Nominally, they are available as they remain rules issued by the Honorable Court. But as has been alleged by several of the petitions, they become illusory under the ATA.
What do you mean nominally?
They remain effective and therefore they can be availed of, Your Honor. But for example, as
Si Inday
pointed
ba
out
mauna
in
magsabi?
the petition filed by Justice Carpio, even if you have a petition for habeas corpus, all the APC or the persons in custody of the person needs to show is the written authority of the APC, and that's that.
We're back dito po sa special coverage ng AlterMidya sa nagaganap na oral argument sa Supreme Court para po sa petisyon para ipanawagan ang pagbasura nito. Ito po si Edge Uyango rin.
And I'm Inday Espino Barona, and I'm going to be raising just a few questions. Edge, who's our next guest?
May mga nakaline up po tayo na mga attorney na magsasalita po, mga lawyer ngayong hapon, Ma'am Inday.
Okay, but there's one question that I want to ask na siguro dito, no? Nabanggit kanina yung designation and why is it dangerous? But many people baka hindi nila klaro sa kanila kung ano. When you say you are designated, ano ba yung proseso dito at bakit napakadelikado ang prosesong ito sa ilalim ng bagong batas sa anti-terrorism?
I-reserve po natin yung tanong na yan. Pero tama ba, Ma'am Inday, ang ibig sabihin nyo, parang halimbawa, sabihin ng Anti-Terrorism Council, itong grupong ito, i-designate nila o i-label nila as a terrorist. Tama po ba? Ganun yung frame nito?
Oo, kasi parang maliit na grupo, malaking poder para magsabi na ikaw ay terorista. Ngayon, malamang ang final judgment nasa husgado, no? Pero sa level pa lang nitong maliit na grupo na to, napakarami ng mga karapatan mo ang ipagkakait dahil lamang sinabi nila at hindi kailangan pa nga pruweba na ikaw ay isang terorista. So, pero yung may proseso kasi ito So, maganda siguro ma-explain sa atin ng ating mga susunod na mga abogado.
Yung mga tanong na yan, I'm sure yan din ang tanong ng ating mga nakikinig sa Facebook, sa YouTube, at nag-aatabay sa Twitter ngayon. Kaya, Ma'am Inday, sabihin ko lang po ulit ang ating mga social media accounts, no? Para makasunod ang ating mga viewers. Once again, tayo po ay may Facebook, facebook.com/altermedia, youtube.com/altermedia, at follow niyo po kami sa twitter.com/altermedia. And para rin sa ating mga media sisters and brothers, no, facebook.com/Kodaw Productions and twitter.com/bulatlat. Inday?
Okay. Sige. So, i-introduce na ba natin ang ating susunod na guest or analyst, no? Na si Attorney Dexter Lopez ng National Union of People's Lawyer, Davao. Magandang hapon, Attorney.
Hello?
Hello? Can you hear me?
Yes, I can hear you loud and clear po. How about
Okay,
my
sige.
signal?
Yeah, you're coming in loud and clear din po. Maraming salamat, no? Attorney, merong naibabanggit kanina na isa sa mga problematic talaga na provision dito ay yung provision on designating, no? Groups of individuals or an individual or an organization as terrorists, no? Na napaka-draconian raw dahil halos walang counter-check ang isang maliit na grupo ng mga mataas na opisyal ng gobyerno na basta na lang tawagin kanyan. And then, of course, the repercussions of such a statement or an action is very, very serious. Pwede mo bang ma-explain to sa amin?
That is true. In fact, I read several of the petitions, apart from our own petition, the one filed by the Mindanao group. By the way, I am the spokesperson of the Union of People's Lawyers in Mindanao. Pasensya na, we always assert our being a separate and distinct group from
Oo
the
nga eh.
NUPL because
We
we are the
apologize,
forerunners
yes.
of the NUPL. We were born
Yeah,
ahead of
oo.
the NUPL. So,
Okay.
yes, designation is different from proscription. Proscription
Okay.
of terrorist groups, nandun yon sa Human Security Act. Ito naman
Oo.
bago eh. This is designation. Yung proscription kasi po, that's a judicial process. The AFP or the Anti-Terrorism Council or the PNP has to file a petition before the regional trial court, and that's what they did under the Human Security Act. And so to seek a proscription, an order, so that the court will designate these individuals, groups, associations, corporations, or what have you as terrorists, no? At least sa proscription on that process, being a judicial process, kahit dito sa anti-terrorism law, sa bago na naman ngayon, pwede na namang ex parte, meaning it's just the Anti-Terrorism Council who will just present, argue their supposed evidence against these individuals and groups, and then the court will have just to evaluate based on their submissions. Pero iba itong designation. It's just the Anti-Terrorism Council itself, acting as the complainant, the prosecutor, the judge, the jury, and the executioner. So the ATC, through the PNP and the different AFP units, will file an application asking or seeking for the designation of certain individuals, a list of individuals or a list of groups to be designated as terrorists. Then that's enough. That Anti-Terrorism Council can then issue a designation. Then this is all ex parte. This is all, kahit pa siguro you will appear there if you are part of the list, they will just ignore you. So that's how dangerous this provision on designation. Kahit nga, as I have said, parang ni-restrict pa rin nila yung proseso sa proscription, at least in the process of proscription, they have to go to court. There is a judicial intervention. At least we are assured, at the very least, that the judicial officer, the judge, will exercise his legal mind, will exercise his discretion, and bearing in mind our lawyer's oath, bearing in mind our code of ethics, our code of professional responsibility, the judge can actually deny their application for proscription. Pero dito sa designation po, tama po yung fears ninyo and a lot of groups. There's no counter-checking. There's no checks and balance. It's all their show. So if they want you to be included in the list of supposed terrorists, you can be designated as a terrorist. And sadly, the remedies under the law are very few. And it would be very difficult. Ganun po talaga. So tama yun na concern.
Okay. And so para lang kasi I'm sure many people know it's dangerous but they may want details. Okay. So granted, for example, ikaw talagang dinesignate ka itong Anti-Terrorism Council. Anong pwede agad mangyari sa iyo?
If you are designated, that's the problem then. If you are one of the persons designated in the list of terrorists, then the danger, the real danger is Section 29 of the law, wherein the Anti-Terrorism Council can cause your detention without warrant. That's it. Because you are one of those listed terrorists, designated as terrorists, pwede na that they can now issue any order for your detention without warrant for 24 days. And therein lies talaga ang napakalaking danger po. Kasi nga, automatic na yun. They can already invoke Section 29.
Okay. So that's something we haven't seen in this country at dire-diretso 24 days pwede kang incomunicado, in other words. And
Yes, and
what
without
can
any
happen to
judicial
you?
intervention po.
Exactly.
Yes. And then the problem here po, may expound. The problem here is that
Yes.
at the end of the 24 days, they can release you. They can release you. But you are still in the list of designated terrorists. After just a few weeks, let us say 1 or 2 weeks, the Anti-Terrorism Council can again cause your arrest and detention. And then you will suffer the ordeal of 24 days incommunicado again without any judicial remedy. And then at the end of the 24 days, they can release you again without charges because they are not required to file charges. And there are no real-world consequences for their acts po. Kasi nga, yung 500,000 na fine for every day of unlawful or unjust detention has been removed from the law. So wala na silang takot. Wala silang takot to be subjected to those hefty fines kasi wala na pong consequence under this law.
And attorney, tama ba that even if you are granted bail, which is pretty hard to do given that you have hardly any access to lawyers and all that, meron pa ring draconian provisions accompanying this? Parang hindi ka makakaalis sa city, etc., na natuloy ba yan, provision na yan?
What I can cite is the provision on allowing the state forces to conduct extensive surveillance upon the consent of the Court of Appeals. So they can conduct 6 months surveillance on you, definitely that will restrict your movement. They can shadow you, they can stalk you, they can follow you, all your movements, and then you cannot do anything po because there is a court order to that effect allowing them to do that. So that's one of the provisions na problematic talaga in this anti-terrorism law.
So, okay, let's go back just briefly to designation. Medyo nakakabahala ito kasi, designating, calling you a terrorist. Pag tinignan natin ang recent actions ng Armed Forces of the Philippines in particular and the defense establishment, makikita natin that they bandy around, the term terrorist, and parang the level of their hysteria seems to be diametrically opposite their intelligence skills, if they have any. So we have they practically quote unquote killed or made dead high-profile journalists, also even the government head of the peace panel negotiations in the previous administration. So parang and hindi ba ang hirap nito is na sideline ang husgado dito, attorney, sa proseso ng calling people terrorists and up to punishing them?
Okay, yes po. If I may cite yung questions, the line of questioning of Justice Carandang addressed to Attorney Cadiz earlier when she asked which government agencies are in conflict now as a result of the powers of the different branches of government are in conflict now because of the anti-terrorism law. And that is exactly the answer of Attorney Cadiz. In essence, na the Anti-Terrorism Council has arrogated upon itself all the powers of the judiciary. Ganun po na sideline. Tama yung term na ginamit po ninyo. Parang naging spectator na lang. When it comes to the anti-terrorism law, it's as if the judicial branch of government is a mere spectator. Kasi nga, even the prosecutors of the Department of Justice, parang wala na rin silang role because the PNP or the AFP can apply for designation as to who will be listed as terrorists. The Anti-Terrorism Council will act on those applications, and then they will approve it. They will release an order listing you as one of those listed terrorists, and then Section 29 can come in without any action from the DOJ state prosecutors in the drafting of a complaint, the filing of a criminal information in court with all the required submissions as to supporting evidence, and then without the court's intervention to review all this evidence and then decide if a warrant of arrest is needed. In this case, wala na po yun, yung entire participation ng judiciary. Wala na po because after you are listed as a terrorist supposedly under a designation, an order of designation, the Anti-Terrorism Council can then cause your arrest and detention without any judicial warrant. So that's practically po, how draconian the anti-terrorism law is. If I may lang po,
Go ahead.
my own opinion, this anti-terrorism law is actually designed to charge anyone and everyone with anything and everything that the state wants to charge you with. Yan po lahat. Any act imaginable can be classified as a terroristic act under Section 4 of the Anti-Terrorism Law. And in effect, Section 9, which will impinge upon the right to free expression, the right to free speech po. That is why what makes our petition, the Tri Peoples of Mindanao, the Lumads, the Moro, and the Christian settlers, is our heavy focus on Section 9, which affects the effects really will be felt on the right to free press, the right to freedom of expression, and sa inyo po mga journalists, no, of AlterMidya, and even those social media supposed influencers. Ito po talaga ang meat ng petition namin. We focus practically our energies, our arguments on Section 9 because this is very dangerous. As lahat po na listed under Section 4 na acts of terrorism, remember those words. Intended to cause. Acts intended to cause. Ganun lang po eh. Acts intended to cause. For example, yung sinasabi nga, interference in government infrastructure or interference in government critical infrastructure. One very good example that we can raise, and I'm not so sure if we raised that in toto in our petition, is that this provision actually now makes any attempt at evil power to become a terroristic act. Kasi nga po, it says, if the intended act causes interference in critical government infrastructure, if 1,000 or maybe 10,000 people converge now in EDSA, a major thoroughfare, in fact, the major artery of Metro Manila, and cause interference there in the flow of traffic, who can prevent the PNP and the AFP from saying that this is exactly what Section 4 is? Causing interference in critical government infrastructure. So, nagkumpul-kumpul kayo doon, You want to petition for redress of grievances, wala na po. That will fall under Section 4. So what is the problem with Section 9? Yung inciting to terrorism. Dito na po ang problema because any coverage by Trimedia, any editorial from any media outlet supporting or supportive of the call for redress of grievances of these people converging in a certain major highway can already be interpreted as inciting to terrorism because you are supportive of what's happening, for example, in EDSA. So, lahat po, the truth is, if these provisions will not be declared unconstitutional by the Supreme Court, I tell you po, there's no more avenue, there's no more way for any people power to happen again.
Thank you so much, Attorney. Alam mo, listening to you, I think the term chilling effect is an understatement. This ibang level talaga ang hinaharap natin ngayon. And we can only wish everybody good luck. But thank you so much. And just one last question. Hindi pa ito logical conclusion of, it's like a narrative arc ng logic na isang president who has always called people like, you're drug addict, you die. You're drug addict, you don't deserve to live. And after getting away with that for 4 years, doesn't this be easy? Isn't it easy for them to accept that?
That's a sad reality po. In fact, para bang kasi hindi na effective as a boogeyman ang talk and killings, ang ubusin ng mga addicts, hindi na effective, or para bang the people are now starting to fight back. In fact, we can feel that sa social media or some sectors of society are already numb. Meron na namang bagong boogeyman. And these are the so-called communist terrorists. And ang targets talaga are the activists, Trimedia who are actually, di ba po, correct me if I'm wrong, the duty of a journalist is not to show both sides of the story, but really to seek the truth. And that's what you do. And if you do that, especially those members of alternative media are agad sinasabing, these are communist sympathizers and therefore sympathizers of communist terrorists again. So, and to po, this is really ridiculous. This is, I really don't know how the picture, the political landscape, and the Philippines will be if the Supreme Court will somehow, I don't know, tao lang po din ang mga justices, and we continue to pray that they will still remember the very first thing that we learned in law school, the very first thing drilled on our heads at the first day of law school. Salus populi est suprema lex, the welfare of the people is the supreme law. I hope and pray that remembering those words, they will shut down all these unconstitutional provisions of the anti-terrorism law. Otherwise, I cannot imagine what kind of Philippines will be living in. This will be much more. This will be Marcos martial law, Marcos dictatorship on steroids times 1,000 steroids. Yun po ang nakikita ko.
Thank you so much, Dr. Attorney Dexter. Maraming salamat. Let's go back to the Supreme Court now and see what's happening there.
Are these the only doctrines that
Trying to say, Your Honor, that mere membership both
Should not
abroad
be.
and under these provisions and under the honorable court's doctrines
Should
cannot be
not.
punished.
Should not be punishable.
No, Your Honor.
Okay, thank you. I think that is the only question left unanswered. Can we have Congressman Colmenares? Yeah, pero congressman pa rin yan, maski noon at saka ngayon, di ba?
Good afternoon po, Your Honor.
Petitioners claim that Section 16 of the Anti-Terrorism Act violates the right to privacy. According to Article 3 of Section 3 of the Constitution, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Don't you think that counter-terrorism activities fall under the exception of public safety or order and thus allow a legitimate intrusion into a person's privacy?
Your Honor, please, we have to go back again to the definition of terrorism.
Can you
under
make it
Section
louder,
4.
please?
Yes, the definition of terrorism allows an unbridled discretion on the part of the military or the ATC, for that matter, Your Honor, to access, record, or collect information, even private information, Your Honor. Imagine, Your Honor, the order of the court in this case, Your Honor, under Section 16, would not even describe with certainty the things or places to be searched. Under the Constitution, Your Honors, please, a surveillance such as this is tantamount to a search. And under the Constitution, a search to be reasonable must have probable cause and must describe the things or place to be searched. In this case, Your Honor, is unbridled.
But we must understand the order of surveillance must be authorized by the Court of Appeals upon application, right?
Yes, Your Honor.
So there are safeguards. In
No,
fact,
Your Honor.
in
Because-
fact, the test is probable cause before the Court of Appeals could issue an order of surveillance.
In fact, Your Honor, it's an ex parte application. And the basis of probable cause of the Court of Appeals is, for example,
Remember,
that an offense has been committed.
so you are against the ex parte application.
Well, Your Honor, I'm just saying this, that the standard
Para,
of
di ba
the
ganun
court-
din ang search warrant? It's
For-
an ex parte application.
Yes, Your Honor, the relevance of ex parte is this, Your Honor's please, that the basis of the court to issue the authorization is an offense has been committed and the effects of the crime can be found in the place to be searched. How can the court know that an offense has been or is about to be committed? In fact, Your Honor, the definition would not give the court standards on what probable cause is, because nobody really knows what the crime being committed or is about to be committed is done, Your Honor's please. So in that sense, the court authorization actually is without probable cause in the sense that the court has no standards to follow with which to issue the
What are the
authorization.
standards to follow, Attorney Cormina,
Pardon.
Congressman?
Pardon po.
What are the standards that need to be followed?
Well,
If probable cause is not enough before a Court of Appeals can issue the order of surveillance,
well,
what could be your standards?
in terms of search, Your Honor, the probable cause would be that an offense has been committed. And then, of course, the effects of that offense can be found in the place to be searched. In this case, Your Honor, it penalizes intention. So how would the court know that an offense has been committed, Your Honor? And so in that sense, Your Honor's please, the probable cause of the judge is based on the allegations of the respondents here in this case, Your Honor.
Okay.
And yes, Your Honor.
Don't you think that terrorism is a very, very grave crime against national security and even a crime against the people's security and life? that before they actually have to do any terroristic act, the state has the right to know the information beforehand through a surveillance ordered by the Court of Appeals?
Well, Your Honor, yes, we recognize the fact that terrorism is a grave and serious concern, Your Honor. However, the court has mentioned so many decisions that it's not a question of expediency. That interest must be, compelling state interest even, must be narrowed down, tailored narrowly by the
Is,
law.
is the
And
gut,
any important compelling interest, if the respondents wishes to do that, must be in consonance with the Constitution, Your Honor. So even if they claim yes, it's very important, it cannot be said, Your Honor, that it because it's important, it's of serious concern. The fundamental rights of others can be violated because of the state interest at hand, Your Honor. The court will surely strike down a law that just because using the concern or the gravity of the crime will violate fundamental rights, Your Honors.
can you honestly believe that the prevention of the commission of a terroristic act can be properly done without surveillance and
Well, Your Honor,
interception?
thank you, Your Honor. Actually, I think the prevention of terrorism need not be through a law like the APA, which is unnecessarily sweeping as to infringe on protected rights, Your Honor. Surveillance, in fact, can be done by state, and it's in the Constitution, it's already in the law. However, in this case, Your Honor, an unbridled discretion, any mode, any personal information using any mode against any person, Your Honor, is really too much of a power given to the ATC, Your Honor. It violates not only unreasonable searches and seizure, but also the right to privacy. And even if it is important to catch a criminal, whether terrorist or not, the surveillance must be done. The Constitution requires that basic rights must be followed, basic steps must be followed. You see, Your Honor, surveillance, if we connote it as is a search. The presumption against a search is that it's for the part of government to prove that the search is necessary.
Can you
That's
not just
what-
consider this as a matter of evidence that if properly excluded, the court can exclude?
Well, in this case, Your Honor, because of the vagueness and overbreadth of the law, the court doesn't even know whether the things or effects that were seized are part, because you see, it didn't even describe the things to be seized. Under the surveillance provision in Section 16, there is no plain view, Your Honor. There is no plain view in the sense that the moment you're surveilled, all information is for quote unquote plain view in the sense that it can be taken by the ATC, Your Honor, even of personal information that is not in any way related to the offense can still be collected and recorded by the ATC, Your Honor. So in that sense, we contend that we understand the concern for terrorism, but it must not be to the detriment and violation of fundamental rights.
Is the probable cause standard not enough safeguard?
Well, the mention of probable cause seems to portray that there is probable cause. For example, Your Honor, a ATC goes to the court and says, well, we have a probable cause that an offense is being committed, for example, and that the things to be seized is in that
Diba,
place.
the probable cause must be established at least
Then
to the
court-
eyes of the judge issuing the order. Hindi lang, there is a probable cause that the act was committed.
Yes,
There
so
must
the
be
judge-
something behind that.
Yes. So the judge will now ask, what offense has been committed?
So are you not
Oh.
comfortable that the Court of Appeals will issue the order on a probable cause?
No, it can't in that sense, Your Honor, because the Court of Appeals will say, so what offense has been committed? Oh, it's an act that was intended. It's an intention, Your Honor.
Can you provide a safe standard, an acceptable and reasonable standard?
For us, Your Honor, the Section 4 actually cannot be cured by any reasonable standard. Your Honor.
Okay. So Section 4 cannot be cured by any
No,
reasonable
Your Honor.
standard.
Even an IRR cannot
The
cure.
definition of the acts there cannot be cured by any possible reasonable standard.
Especially in an IRR, Your Honor, because the IRR can go behind the law. And IRRs can be changed anyway, while the law cannot be changed. So it is not for the IRR to provide safe standard, Your Honor, because IRRs are just not the laws that Congress has passed. So even if the IRR tried to cure, the law does not require it. So therefore, the ATC can always say, well, it's not in the law. And anyway, if you want the IRR, can be
Okay, Attorney
interpreted.
Colmenares, let's go to another point.
Thank you.
We go to proscription.
Prescription, Your Honor.
Proscription of terrorist organization.
Yes.
Is that a matter assigned to you?
Pardon, Your Honor.
Huh?
I didn't hear
Is the
your-
subject matter assigned to you?
Well, it only as far as bill of attainder and ex post facto law, Your Honor. I think
Sino ang because you divided the law into several issues.
Attorney Ursua, Your Honor, is on-
Okay. Attorney Ursula will be able to answer the questions on proscription. Attorney Colmenares, thank you. In fact, si Attorney Ursula ang next.
Thank you, Your Honor.
Attorney Ursua?
Designation and proscription kay Attorney Ursula. Ano ba ang effects ng preliminary proscription order by the Court of Appeals?
Your Honor, under Section 35,
Section?
under Section 35 of the ATA, the AMLC can either examine the accounts, the bank accounts or investments of the person prescribed, whether preliminarily that is, or freeze the assets, Your Honor.
So it's
But
in in relation to the power of the AMLA.
Yes, Your Honor, among other things, can also lead to arrest, detention of the person, as well as prosecution. However, let me point out, Your Honor, that the prescription under Section 26 is not required for there to be examination of deposits or investments.
Respondents here in this case, Your Honor. And yes, Your Honor.
Don't you think that terrorism is a very, very grave crime against national security and even a crime against the people's security and life? That before they actually have to do any
We're back dito sa studio ng AlterMidya para sa special coverage nitong nagaganap na oral argument sa Supreme Court. Narinig po natin kanina ang patuloy na pagsasalita ng ating mga petitioner lawyers regarding the arguments. Particularly, they are talking about Section 4, Section 9, and Section 29. And a while ago, we had an interview with the UPLM lawyer, Dexter Lopos, and he mentioned that the welfare of the people is the supreme law. Kaya mahalaga pong mapag-usapan natin kung ano nga ba ang nagva-violate nitong mga provisions ng batas na ito sa democratic at constitutionally guaranteed rights ng mamamayan. Makakasama natin ngayong hapon sa ating Zoom ang atin pong dating Bayan Muna representative at ngayon ay convener ng Movement Against Tyranny na si Teddy Casino. Magandang hapon sa iyo, Teddy.
Magandang hapon, Edge, at magandang hapon po sa lahat ng nanonood.
Teddy, your initial thoughts on the proceedings na nagaganap ngayon sa Supreme Court?
Well, para sa akin, very educational itong nangyayari. Medyo nalulunod na nga ako sa mga legal terminologies, yung mga mala prohibitum and iba pang mga Latin terms. Pero maganda kasi natututo rin tayo kaugnay ng ilang very technical aspects ng batas. Halimbawa lang, yung mala prohibitum. Nabanggit kanina ni Justice Carandang yan sa kanyang interpellation. Lumalabas, at doon sa pagkakaintindi ko, yung mala prohibitum, merong presumed intent o presumed criminal intent yung isang suspect. So kung i-apply mo dito, dahil sabi nila yung Yung anti-terrorism law is a special law. Therefore, mala prohibitum. Therefore, presumed yung intent. So, yung mga legitimate activities like protest actions o nagrally ka o nagwelga yung union, pag sinabi ng otoridad na act of terrorism yan, it presumes that there is that intent to commit terrorism. So, mas naunawaan ko na talagang delikado pala itong anti-terrorism law na ito. Kasi talagang pwede siyang gamitin sa mga napaka-ordinaryong aktibidad, mga bagay na ginagawa ng karaniwang tao, and then sasabihin lang ng otoridad, ito yung intention mo. Ang intention mo, manggulo. Ang intention mo, manakit. Ang intention mo, makapatay ka. And then, it is presumed na may ganong intention ka. So yeah, very educational. Medyo ano lang, para kang nagsisit in sa isang classroom ng mga abogado.
Para tayong mga law students, no?
Oo nga.
Teddy, itong mga tanong natin regarding sa comparison, no? Kasi kanina tinanong natin yung concept ng martial law noong 1970s at ngayon ay terror law. Ano ang comment mo dito?
Siguro parehong epekto pero magkaibang paraan. Ang martial law kasi hindi na natin naabutan yan edge. Pero ang martial law, ito yung ano talaga sinasabi nating open fascist dictatorship na ginawa ni Marcos. Sinarado ang Kongreso, pinadlak ang mga korte, tinake over yung mga media, isang dyaryo lang ang umaandar, and then may curfew, anti-subversion law, bawal mag-meeting, pinagbawal yung mga organisasyon, kahit yung mga organisasyon ng estudyante. So yung ganon, di naman natin nakikita sa ngayon. But in effect, sa ilalim nitong anti-terrorism bill, pwedeng gawin yan kahit hindi itinideklara ang martial law. Lalo na sa bahagi ng mga mamamayan, tayong mga ordinaryong tao. Siguro ang Congress, nandyan pa rin yan, ang mga korte, hindi bubuwagin, yung media, negosyo naman yan. Pero tayong mga ordinaryong tao, lalo na yung mga organisasyon na naghahangad ng pagbabago, na bumabatikos sa mga maling gawain ng gobyerno, yun ang mga pinaka-vulnerable dito. At yun ang patatahimikin sa pamamagitan ng batas na ito. So, wala mang lantad na deklarasyon ng batas militar. Sa pamamagitan nitong anti-terrorism law, mapapatahimik, matatakot nila ang mga mamamayan na questionin ang nasa otoridad. And essentially, that is what dictatorship is all about. Yung wala nang makapagreklamo. Yung hindi ka na pwedeng umangal o umalma. At lalong hindi ka pwedeng kumilos para magkaroon ng makabuluhang pagbabago sa kasalukuyang sistema. At yun ang iniiwasan ng iba't ibang mga grupo na mangyari, kaya naghain ng kaso sa Korte Suprema.
Teddy, we are 1 year before the national elections, no? 2022, napakahalagang panahon ito para sa Kongreso at sa national elections. Do you think itong pagpasa nitong terror law at itong nangyayaring proceedings ngayon, ano ang mga scenarios na nakikita ng movement against tyranny if ever they will push through, if ever the Supreme Court approves this law?
That's a very good question. Kasi kadalasan, pinag-uusapan natin yung anti-terrorism law sa usapin ng civil liberties, ng human rights, ng government abuses. Pero yung isang angulo dyan na maganda na mention mo is that there will be an elections in 2022. At definitely, itong batas na ito, sa kamay ng isang administrasyon na gustong ipanalo yung kanyang mga kandidato sa susunod na eleksyon, magagamit talaga itong anti-terrorism law. Unang-una na lang, ideklara mong terorista yung mga kalaban mo sa politika, effectively, bawal na sila. No? Halimbawa, sabihin ng Anti-Terrorism Council, yung bayan muna, itong mga party list na ito, sa ilalim ng Makabayan Bloc, sila ay mga front ng terorista, therefore sila ay bahagi ng terrorist movement, therefore sila ay designated, eventually ipagbabawal, di hindi na pwedeng tumakbo sa 2022 elections. At hindi lang yan, yung Liberal Party, halimbawa, sasabihin, yung Liberal Party providing material support to the terrorists, pwede rin ipagbawal at ipahinto yung mga aktibidad ng Liberal Party, halimbawa, o kung sino mang partido na katunggali ng administrasyon. Iyan ang mga posibilidad kapag finally ipinatupad at nakalusot sa Korte Supremang itong anti-terrorism law, malamang sa hindi ay gagamitin ito para sa electoral agenda ng gobyernong Duterte, kahit na hindi maipagbawal, no, yung mabansagan lang. Halimbawa, yung Anti-Terrorism Council, which is directly under the President, sabihin ng Anti-Terrorism Council, ito yung mga terrorist organizations, ito yung mga kasabwat ng mga terorista, kasi sa ilalim ng batas may kapangyarihan silang gumawa ng listahan na yan. Malagay ka lang sa listahang yon, mabigat na ang epekto noon sa iyong electoral chances. Kasi isang matinding issue yan, isang matinding paninira yan na official government agencies ang nagsasabi.
Mamaya po ipapasok si Inday para po sa ilang mga tanong. Pero bago po ang kanyang tanong, eto muna Teddy. Kanina ang napansin ko, sabi ni Attorney Dexter Lopez, para kang may big brother na naka-wiretap, naka-masid sa iyong social media, no? So ano ang itingin dito ng Movement Against Tyranny kung ito'y tuloy-tuloy na paano yung ating mga kalayaan sa ating mga social media accounts?
Actually, yun yung bago tayo nagsimula, yun yung pinag-uusapan ni Nery Colmenares tsaka ni Justice Carandang. Tinatanong niya yung usapin ng surveillance. Sinasabi ni Justice Carandang, total, dadaan naman sa Court of Appeals. No? Court of Appeals naman na magsasabi kung pwede mag-surveillance ang PNP o ang Anti-Terrorism Council or ang Armed Forces of the Philippines sa'yo. And surveillance includes electronic surveillance. So kasama yung iyong email, yung mobile phone, yung iyong mga text, yung iyong mga messages, no? Lahat, no? Pati ng electronic communications kasama dyan. Sabi ni Justice Carandang, dadaan naman sa Court of Appeals. Ang Court of Appeals naman, malinaw ang pamatayan ng probable cause. There are standards na dapat sundin ang Court of Appeals. Kaya lang, ang problema dito, yung mismong batas na pagbabatayan ng Court of Appeals, which is the anti-terrorism law, napakaluag at napakasaklaw ng kanyang definition ng terrorism. So pwede ngayon mangyari na sabihin ng Anti-Terrorism Council sa Court of Appeals, itong si Mr. A, nag-oorganisa ng union. Tingin namin ang intention niya guluhin yung kanilang komunidad at maghasik ng terorismo. And because there are no standards vague yung definitions dyan ng terorismo, ang pagbabatayan lang ng Court of Appeals yung sinabi ng Anti-Terrorism Council. Walang elements Ang elements lang yon, the intention to harm or the intention to interfere with public transportation or with infrastructure. Napaka-ano nun, napaka-vague nun. No? Unlike yung other crimes na malinaw yung elements, dito sa terrorism wala. Kaya nga kahit nadadaan siya sa Court of Appeals, dahil napaka-malabo at napakasaklaw ng definition ng terrorism, anyone can be subject to surveillance. And doon na nga papasok, pati electronic surveillance, including email, social media, hindi pa nga naipapasa itong anti-terrorism law. Ilang mga nag-post lang sa Facebook ng tungkol sa COVID-19, inaresto na. No? At sinabing kung inciting to sedition o kung anong mga charges na ginawa. Bumatikos lang kay Duterte, pinatawag na ng pulis at kakasuhan, inimbestigahan na ng NBI. What more? Itong mga organizations na paghihinalaan nila o babansagan nilang mga terorista.
Alright, we welcome back Ma'am Inday sa ating conversation. Inday?
Hi, kamusta, Teddy? Okay, pag-usapan natin intention. No? We've heard government officials, the military in particular, and the police, but even Malacanang, also spout one conspiracy after another. And obviously, even in hearings in the Senate, yung kanilang prime witness or expert, wala halos mabigay, no, na mga ebidensya. And at one point, I think, naisabi nga na kasi nga dahil hindi kami, alam namin na hindi tatayo ang aming mga akusasyon sa korte, ay kailangan propaganda yung ginagawa nila. Doesn't this anti-terrorism law actually allow them now a platform, kung saan hindi kailangan lagyan ng mabigat na ebidensya ang isang paratang laban sa isang tao o grupo, and yet magkakaroon na ng tinatawag na punishment even before judgment, because obviously the provisions that come with mere designation, which also has a very low threshold of evidence, are to some extent already tantamount to actually a judicial penalty, except that it doesn't pass through the judicial process.
Precisely, Inday. Yung intention kasi, at pinag-usapan ito doon sa ilang questions doon sa hearing, napakadaling i-ascribe ang intention eh. Nagwelga yung manggagawa, nagbarikada sila sa pabrika, pwedeng sabihin ng may-ari ng pabrika, ang intention niyan, patayin ako eh. Intention ng mga manggagawa, patayin yung manager ng pabrika. And how do you prove that? And yun nga, lalabas because it is a special law, intention is presumed. So parang mapupunta ngayon ang burden doon sa inaakusahan na hindi, wala kaming intention na siya ay patayin. Pero yun ang problema sa intention eh. Ang hirap patunayan at ang hirap ding pasubalian. Kasi, ano yan, intention yan eh. Nasa isip yan eh. Hindi naman yan nakasulat, hindi naman yan malamang. Kung illegal ang intention, hindi naman binibigkas. And precisely, yun na nga, nawawalan ng saysay yung due process pag ganyan. At dahil on the mere basis of that, on that intention, pwedeng ang anti-terrorism law gumawa ng listahan ng mga designated terrorists, pwede nang i-freeze yung mga accounts ng mga nasa listahang yon. And eventually, later on, the court can issue a probationary o a preliminary proscription. O ibig sabihin, hindi pa natapos yung proseso sa korte, pero preliminary, ipoprescribe ka na namin, ipagbabawal ka namin habang pinag-uusapan pa sa korte yung pagbabawal sa'yo, talagang ano yan, nalalagay sa delikado ang maraming mga organisasyon na pag-iinitan ng kung sino man ang nasa poder.
Yeah, and still on intentions, and the loose way where government officials ascribe intentions to certain groups of people. Former Justice Carpio and former Justice and former Ombudsman Carpio Morales ay mismo tungkol dito sa isang medyo mahabang post ni General Parlade, no? Kung saan sabi nila threat, no? Pero actually dito, parang kung titingnan natin, yung threat na sinasabi nila at inulit yata kanina rin ni Attorney Cadiz, no? yung very soon blood deaths will be settled, the long arm of the law will catch up on you and your supporters. Hindi hindi NPA ang binabanatan, no, ni Parlade, kundi actually mga makabayan Solons, no? And dito papasok natin yung intention kasi tinanong niya what is your agenda, no? Ang sinabi niya at ang tapos biglang may day of judgment na dahil ito raw mga nag-o-oppose sa anti-terror law are people who would want the CPP-NPA to triumph over the land, which is pretty much, it, inano na pinasok niya na lahat, no? From intention papunta sa threat. And I think this is talagang strines kanila Justice Carpio, members themselves on the Supreme Court not too long ago, na this is one major example of why an anti-terror law this draconian would be very dangerous, especially to activists. And you're no stranger to that, Teddy, even under previous laws, no?
Actually, totoo yan. Ang binabantaan ni General Parlade ay lahat ng mga petitioners, no? The 37 petitioner groups na nag-question sa Korte Suprema. Yan ang binalaan ni General Parlade. Kaya kahit si former Justice Carpio at si Carpio Morales, nangangamba. Kasi kasama sila doon sa babantaan na deaths will be paid. No? Parang dadanak ang dugo. Ganon din sa mga organisasyon, for example, ako sa bayan, yung ginagawa ko minsang pagsasalita sa mga paaralan, no, na imbitahan tayo magsalita sa isang forum, magpaliwanag tungkol sa mga issue. Para sa atin, ordinaryong ordinaryong pagpapahayag, ordinaryong pagbibigay kaalaman sa ating mga kabataan. Pero para sa mata ni General Parlade, sa mata ng NTF-ELCAC, yan ay radicalization of the youth para sila ay mamundok at mag-armas. Medyo malayong-malayo na yon, pero ganun ang kanilang klase ng mindset. At dahil dyan, ang tingin nila sa ginagawa mong pagsasalita, pag-expound tungkol sa mga issue, para sa kanila, bahagi na yan ng terorismo. Bahagi na yan ng radicalization of young people to be recruited into the so-called terrorist group na mag-armas. Kaya talagang, yung ganitong klaseng kaluwag na batas, ilalagay mo sa isang institution, PNP and AFP, na ganyang klase ang pag-iisip, para makikita mo na kung saan patutungo ito. And eventually, yung mga tao, yung mga organisasyon na hindi naman nag-aarmas, hindi naman terorista, wala namang ginagawang bawal, sila pa ang tatamaan nitong batas. Samantalang yung mga totoong may armas at lumalaban sa gobyerno, hindi naman nila makakasuhan dahil nasa bundok yun . Ang kakasuhan nila at tatamaan yung mga ordinaryong kumikilos sa legal parliamentary struggle.
Teddy, there was an interesting exchange, no? Dito yun si Attorney Ursua ang tinatanong, na hindi ba na ang Anti-Terrorism Council raw ay parang prosecutor lang, Pero parang paano sila maging prosecutor? Hindi naman sila nasa ilalim ng Justice Department, no? At pangalawa, maganda nga parang yung sagot ni Attorney Ursua is, ang prosecutor ay hindi nag-aaresto, hindi nagde-detain, at hindi rin nag-o-order ng freezing of assets. Nagsasampa sila, no, para makapag-order ang korte nito. Unlike the anti-terrorism, practically becomes a pseudo court that orders the things that normally only courts should order.
Actually, nga sila prosecutor, judge, and executioner . At yan, tingin ko lahat ng 37 petitioners, sinama yan sa kanilang petition. na sobra-sobrang kapangyarihan ang inilagak sa Anti-Terrorism Council, which is an executive body. No? Ibig sabihin, it is a political body. Hindi siya judicial, hindi siya legislative. So, pero inilagay ang kapangyarihan sa Anti-Terrorism Council to interpret this law, to prosecute, and even to issue essentially arrest warrants. Kasi yung authorization ng Anti-Terrorism Council ay pwede nang batayan para sa pag-aresto ng mga tao ng hindi lang 3 araw, kundi hanggang 24 na araw. So medyo super body itong itinayo. Para sa akin nga, parang Gestapo yan. No? Hindi parang prosecutor, parang Gestapo yung Gestapo ni Hitler, yung Anti-Terrorism Council.
Okay, so basically we're calling it's a capture of powers by a small group of executive officials.
Na mostly generals ho yan. Mostly, people
generals,
involved in the security sector. So parang junta. Sabihin na natin, parang junta ang Anti-Terrorism Council.
Okay, which habang sa ibang bansa ay medyo nare-recover na ang democracy that was under attack in the last 4 years, in Asia, specifically Southeast Asia, after Myanmar, where there was an actual coup, in the Philippines, as we say, hindi kinakailangan ng actual martial law. They've done it through a legislative coup. How would you, what phrase would you give for this, Teddy?
Hindi siya coup kasi binigay kay Duterte on a silver platter eh.
Capture na lang.
It is a conspiracy, no? It is a conspiracy of the Duterte clique, both in Congress and in the executive, para magkaroon ng martial rule sa ating bansa in the guise of anti-terrorism. At sana ang hudikatura, sana ang Korte Suprema ay hindi magpasailalim sa conspiracy na yan, no? At i-uphold yung ating civil liberties, ang human rights, ang ating constitutional freedoms. Kaya mahalaga itong labanan sa Korte Suprema kasi nga yung dalawang branch nagsabuatan na yan. At tumatakbo tayo ngayon sa pangatlong sangay ng gobyerno para pangalagaan ang ating demokrasya. And that is what is at stake in these hearings.
Okay, siguro last question, Ted, before we go back to the Supreme Court. Okay, in real terms, the potential fallout of this law. Alam natin na ang dami-daming, one of the main factors for conflict and unrest, especially outside of Metro Manila, in our countryside, is usually big-ticket development incursions, into peasant lands or indigenous lands. How would something like the anti-terrorism law affect the ability of indigenous people, supposedly right now protected by a law that gives them self-determination and self-empowerment over their ancestral lands? How would this dilute what has been given them, no matter how imperfect this gift has been?
Let's look at some concrete examples. Halimbawa dyan sa Didipio Mines sa Nueva Vizcaya. Ang mga taga-community dyan ilang buwan na, no, o ilang taon na yung kanilang barikada laban sa pagpasok ng isang malaking foreign mining firm. At yan talagang barikada yan, at nagkakaroon ng initan dyan kapag papasok yung mga truck ng mga mining firms. Under this new law, pwedeng sabihin ng gobyerno na itong mga nagbabarikadang mamamayan na ayaw ng nakakasirang mining operation sa kanilang komunidad, they will be charged with terrorism. Kasi yun na nga, dahil nga napakaluwang ng definition ng terrorism, madaling mag-ascribe ng intention sa mga yan So ang magiging crime nila is not merely preventing the entry of trucks, not merely yung peace and yung disturbing the peace. Ang magiging crime nila, terrorism. At mabigat ang magiging implication sa komunidad. Puntahan natin yung mas matinding example sa Mindanao. May mga communities dyan na sa kanilang paglaban sa mga malalaking mining companies talaga nag-aarmas. They take the law into their own hands dahil sa tingin nila, hindi naman tinutugunan yung kanilang interes ng gobyerno. Talagang nakikipagbarilan ito sa mga security guards ng mining company, minsan sa mismong pulis, kasi nga, ang what is at stake for them, yung kanilang komunidad, yung kanilang karapatan na manatili dun sa lugar na nais kamkamin ng mga mining companies. Their crime will now be terrorism. No? At ang magiging trato sa kanila ay terorista. Hindi yung mga lumad communities merely defending their right to self-determination. So mabigat yan. And hindi lang ganong extreme cases ang makikita natin. Yung mga taga-UP ngayon na sinasabing kuta ng mga komunista, kuta ng terorismo, sila rin ay maapektuhan. Not only UP, 38 schools na nga ang binabanggit ng NTF-ELCAC ngayon na pinamumugaran daw ng mga teroristang komunista. So they will also be subject to surveillance. They will be subject to curtailment of rights using this law. At ang problema dyan, kapag napatahimik mo na yung mga aktivista, pag napatahimik mo na yung mga NGOs, pag napatahimik mo na ang oposisyon o yung mga kritiko ng gobyerno, madali nang patahimikin yung mamamayan. At yan ang, at the end of the day, it will allow those in power na mas lalong magsamantala, mas lalong mag-abuso dahil yung mga lumalaban sa abuso at korupsyon at pagsasamantala, tinawag na nilang terorismo. Terorista, kinulong nila bilang mga terorista at wala nang pwedeng makasama ang ating mamamayan sa paglaban. At mismo yung mamamayan ay matatakot na, no? At mawawalan ng mawawalan ng mga kilusan na magdedepensa sa kanilang mga karapatan.
Okay, well said, Teddy. So, bale, sinasabi mo ni Teddy dito, no, na parang kapag tinawag mo ng terorista at nabigyan ka ng poder, na basta-basta na lang, ma-assault, ma-punish with very little judicial oversight, ang mga rights defenders, ang mga taong naghahabol ng accountability, ang mga advocates of the environment and good governance and whatnot. Basically, that is the perfect formula for impunity. Maraming salamat, Teddy. We're going to go back to the Supreme Court right now.
Maraming salamat, Inday. Magandang hapon po sa inyo.
As the court has rendered decisions questioning the constitutionality of Section 11 of RA 10168, the decisions of the court focus solely on the ex parte application by the AMLC for the issuance of bank inquiry orders. But the court has not had occasion to rule on whether the ex parte examination by the MLC of the examination by the MLC of deposits or investments without any court authorization is constitutional and valid. And so for that reason, Your Honor, what the petitioners are submitting before this court in these cases is that the court should look not only actually at Section 35 and Section 36 of the ATA, but also related provisions or provisions of related laws such as RA 10168.
Now, would you agree that there are also instances when searches are reasonable even when warrantless? And case law has enumerated some known jurisprudential instances of reasonable warrantless searches and seizures.
Yes, Your Honor, but the same cannot be compared with the examination conducted by the AMLC under the ATA, Your Honor. We submit that the search or the examination, which is equivalent to a search actually, being conducted by the AMLC under the ATA is unreasonable and therefore unconstitutional.
Now, would you agree that one of the exceptions is exigent and emergency circumstances?
Yes, Your Honor, but we also believe that that does not justify giving the AMLC, Your Honor, unbridled power to make an examination of bank records without court intervention.
Would you consider an impending threat of terrorism as an exigent or emergency circumstance which would allow the freezing or examination of the bank accounts of a terrorist or his financier despite the absence of judicial warrant?
Not without, Your Honor, violating due process.
But
Your
this
Honor.
is an exception under the case of People versus Coaget.
Yes, Your Honor, we agree that it is an exigency. However, we question that, Your Honor. Under the ATA, we believe that the AMLC should follow Section 2, Your Honor, of Article 3 of the Constitution. We believe that is an unreasonable search, the
Anyway-
power that is given to the AMLC.
Anyway, can you elaborate this in your memorandum?
Yes, Your Honor.
All right. Thank you very much, Attorney Ursua. Can I
Thank you,
call
Your
on
Honor.
Congressman Lagman?
And we're back dito sa studio ng AlterMidya para sa special coverage dito sa nagaganap na oral argument sa Supreme Court
Good
para po
afternoon,
dito sa anti-terrorism
My question
law.
is Section
At narinig
29
po
of-
natin kanina si Attorney Evelyn Ursua, isa sa mga petitioner lawyers laban dito sa batas na ito. Kanina po ay na-feature na rin natin ang iba't ibang mga petitioners gaya po ng ating naging mga panauhin na sina Attorney VJ Topacio ng Center for Trade Union and Human Rights, Attorney Dexter Lopos ng Union of People's Lawyers in Mindanao, at ang dating Bayan Muna representative na si Teddy Casino. Another petitioner will be sharing his views about the ongoing oral arguments. Atin pong i-welcome sa atin pong discussion mula po sa San Lakas at isa ring petitioner lawyer, Attorney JV Bautista. Magandang hapon po, Attorney Bautista.
Magandang hapon sa iyo, Edge. Magandang
Good
hapon
afternoon,
na
Attorney.
Inday, at sa lahat ng nagsusubaybay sa inyo dito sa inyong podcast na ng isang napakahalagang pinag-uusapan sa bansa natin ngayon.
Attorney JB, okay. Ano yung tatlong pinakatingkad na para sa iyo dun sa mga argumentong iniain ng mga petitioners ngayong hapon?
Alam mo, kanina pa ako nakikinig magmula nung nagsimula, magagaling yung ating mga arguers doon. Pinamumunuan nila Congressman Nery Colmenares at sila Dean Jokno at of course si Congressman Lagman. Magagaling sila. Even the younger lawyers have proven their mettle before the questioning of the Supreme Court justices. Sa akin kasi ang aking nakikita dito sa petition na to, ang talagang pinakamalakas na maiidulog sa Korte Suprema ay yung pagke-question doon sa Section 4 ng batas ng anti-terror law. Ito yung definition ng kung ano ang terorismo. Kasi ito medyo nuance lang to, Inday and Edge, mas na-appreciate ito ng mga abogado kasi yung isang batas, pagka yan may question ng constitutionality, normally, pwede mong questionin yan kapag naapektuhan ka na. Yun ang tinatawag na standing sa husgado. Pagka kasi wala kang standing, hindi pwedeng dinggin ang petition mo. Kailangan ikaw ay apektado ng batas. Yun ang tinatawag na as as applied for, no? Kaya lang merong mga exceptional instances na pinapayagan ng Korte Suprema, pinapayagan ng ating batas na questionin mo ang isang pinasa ng Kongreso na batas at questionin mo ang constitutionality niya on its face. Ibig sabihin nito, kahit hindi ka apektado doon sa batas, pero yung batas na yan ay may kinalaman sa paglabag sa freedom of expression at sa free speech, maaari kang pumunta sa Korte Suprema at humiling ka ng isang on its face challenge or yun yung tinatawag na facial challenge. Sa ganang amin, hindi na kami masyadong naglabas ng marami pang mga pagkukulang at maraming mga depekto ang batas. Alam mo, talagang tad ng depekto itong anti-terrorism law na to, no? Marami talaga at maraming nakakatakot na provision. Kanya lamang may konting technicality dito na baka abogado lang talaga ang makaintindi at maka-appreciate. Kung ano ang pwedeng tignang mabuti ng Korte Suprema para magkaroon ng pagkakataon na bigyan nila ng due course at eventually kahit na makakuha ng panalo doon sa kaso ng mga petitioners. Meron kasing dating, if you remember, nung 2007, meron ng anti-terror law na pinasa. Ito yung Human Security Act of 2007 na ipinasa nung panahon ni GMA. Ngayon, noong taong 2010, that was already 20 years ago, no? 20 taon na, 10 taon na pala. 10 taon na ang nakakaraan. Marami kasing nag-file din ng petition pero hindi ganito karami, hindi 34. Noon ay 6 lamang ang mga petitioners. At ang naging pamagat nitong kaso na ito ay Southern Hemisphere Engagement Services versus Anti-Terrorism Council. At dito sa kasong ito, hindi pinayagan ng Korte Suprema yung pag-declare ng unconstitutional yung Human Security Act dahil, sabi niya, hindi kayo pwedeng pumasok sa facial challenge. Dahil hindi kayo apektado doon sa hindi na violate ang rights nyo ng batas. Kaya on a technicality, hindi diniklara ng Korte Suprema na unconstitutional yung Human Security Act of 2007. Ang sinabi ng Korte Suprema, kung gusto ito, yes, Inday.
Okay. Why do you think, from your end, why do you think there's a better chance today that this on your face, facial challenge, will succeed where yung previous, for example, hindi
Ganito. Kasi, alam mo, Inday, ang nakikita ko kasi dito, ang talagang Achilles heel nitong batas na ito ay yung Section 4 niya. Yung definition ng kung ano ang terorismo. Kasi tignan nyo ha, yung Anti-Terror Act of 2020, sinasabi niya, yun daw advocacy. Advocacy yan, di ba? Protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights, okay daw yan. Subalit, kapag ang mga ito ay intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety, o kaya, when its purpose is to intimidate the general public or a segment thereof, create an atmosphere or spread spread a message of fear to provoke or influence by intimidation the government or any international organization, or seriously destabilize or destroy the fundamental political, economic, or social structures of the country, or create a public emergency or seriously undermine public safety. Napakalawak niyan.
General strike, A general strike would fall under that, right? Parang ganun na yung ginagawa nila. It's you're intimidating the
Alam mo
like if
Inday,
you
ito
want to
kasi
kick the net.
ang mapapansin mo dito, ha? Yung exercise mo of these freedoms, kasi ito protected freedoms ito eh. Mga ginagamit ito ng mga iba-ibang mga organisasyon, kamukha sa amin sa Sanlakas, ano? Advocacy, ganyan, di ba? Mass actions. Ginagamit ito in order to communicate and express a certain position. Ngayon, dapat ito protektado ng saligang batas. Pero kung sinasabi ng Anti-Terrorism Act na kapag yung mga ginagawa nyong yan, which is an exercise of a right, ano? Merong ganitong intensyon. Ngayon, who is there? Who is going to determine what is that intention? Who is going to make a determination of what is that purpose? Ayan, diyan na pumapasok yan. Kasi normally pag nangyari yan, yung mga arestuhan, yung mga hulihan, nandoon na sa mismong mass action eh. Kaya yung mga police officers ang gumagawa niyan. Sila ngayon ang nagdedetermina kung ito intended o kaya may ganitong klaseng purpose in order to arrest people because they are already engaging in acts of terrorism. Kaya nga, dito sa sitwasyon na to, because of Section 4, pwede nang pumasok ang mga mamamayan at maghain na ng tinatawag na facial challenge. Kasi itong mga karapatan na ito ay karapatan ito upang magpahayag. These are freedom of expression and free speech na protektado ng ating saligang batas. Na kapag ito ay sinagkaan ng isang batas, kahit hindi ka pa naapektuhan, halimbawa, kamukha namin, as petitioners, hindi pa naman nangyayari yon. Pero because this involve freedom of expression and free speech, pwede kang maghain ng facial challenge. At naniniwala po ako na ito ang isa sa mga pinakamalakas na maiihain na argumento. Kanina, I was listening to Dean Jokno and I think he did a splendid job. Napakaganda nung kanyang presentasyon nung sinabi niya, kung ito ang pakahulugan o definition natin ng terrorism, yung ginawa ni Cardinal Sin noong 1983 nung people power natin ay yun ang 1985 people power yung EDSA 1 magiging act of terrorism yun pagka ginawa ngayon kasi it will fall under this definition of what is terrorism. I think Inday. Yes.
It sounds like even a major transport strike would probably qualify to have the ATC brand people terrorists there.
Exactly.
Parang napakalawak eh. Okay. But
Exactly, Inday. Exactly.
May isang kasi, several of the councils earlier pointed out na yung gobyerno raw yung IRR. So, merong attempt to correct critical problems through the IRR. Bakit hindi ito dapat ina-encourage? Why is this practice bad?
Yung IRR, hindi technically yan batas eh. No? These are administrative issuances. Mas mababa ang ranggo niyan kesa sa batas. In other words, pagka nagkaroon ng conflict sa pagitan ng batas at ng IRR, mas masusunod yung batas. Kasi yun ang batas yun ang ipinasa ng Kongreso. Let's remember that the IRR was just issued by an administrative agency, no? I believe I don't know if it's the DOJ or the Anti-Terror Council which issued it, pero executive lang yan. Purely executive issuance yan. In other words, hindi niya naman pwedeng baguhin kung ano yung sinabi ng batas By definition, implementing lang siya. Ngayon, kung sabihin natin, merong magsabi ng pulis, hindi naman yan ang sinabi ng batas IRR yan. Masusunod yung batas. Kung yung batas mo, to begin with, defektibo na, hindi pwede gamutin yan ng IRR. Either kailangan yan amendment to the law O kaya naman, kung ayaw namang i-amend ng ating Kongreso, pumunta tayo sa husgado at pakita natin sa husgado na yan ay lumalabag sa ating saligang batas and it will be declared as null and void for being unconstitutional.
Okay. Another question. Itong provision of freezing assets, gaano ba kadelikado ito sa civil society? No, kasi it's one thing na dati kasi pwede ka naman talaga mag-freeze, idadaan mo sa husgado. Ngayon, parang ang bilis-bilis na pwede mag-freeze. So it could be that schools and other institutions who may not fall in line immediately with the orders of the military or the government for that matter could be dragged as accessories and then find also their assets and accounts in danger of being frozen.
Yeah, kasi mabigat itong maraming yung aking section 4 na sinasabi, no, definition yan ng terrorism. Basically, yan ang sinasabi na kung ano ba yung terrorism. But there are many other acts of terrorism pa in the law, including yung mga tinatawag na proposal, conspiracy to commit terrorism, which are all also penalized. Kasi sa ordinary crime, alam mo yung proposal, hindi naman yan pinaparusahan unless national security laws ang national security crimes, like proposal to commit treason or proposal to commit rebellion, yan may pinaparusahan yan. Pero proposal to commit a common crime, hindi pinaparusahan yan. Itong Terrorism Act, pinapasok niya rin yung mga proposal, yung mga inciting to commit, yan mga conspiracy, crimes na yan in themselves, no? Alam mong diferensya, Inday, kasi nitong kaya yung mga tweet na yan, yung mga lumalabas sa social media. Kapag yan in the eye of the Anti-Terrorism Council o kaya kahit na mga law enforcement agencies lang, pakahulugan nila, interpret nila na yan in the commission or in support of or proposal to commit or inciting to commit terrorism, maaari ng maging basihan yan para arestuhin ang involved na tao diyan. Dito kasi sa doon sa nakaraang anti-terror law, yung tinatawag na Human Security Act of 2007, merong tinatawag na predicate crime. In other words, meron ka munang ginawang krimen, tapos yung krimen na yon madidikit mo sa terroristic act. Dito sa sa 2020 version, wala na yun Wala nang tinatawag na predicate crime. In fact, ang pinakamasama nga nito, kahit yung exercise of civil rights like the freedom of expression at saka free speech, kapag qualified na siya na may ganitong intensyon o ganitong purpose, nagiging na siyang act of terrorism. Ito ang mabigat dyan.
So, Attorney JB, media outfits are also vulnerable here. Kapag let's say, na-designate ang Sarlakas, for example, as a terrorist organization, but media outfits being what we are, we give play to as many voices as possible. What happens to a media outlet if it insists on covering as a legal organization that has suddenly found itself designated as terrorist by a small group of men?
Oo. Talaga yung it is a very possible scenario na media practitioners or for that matter, Inday, kahit na media outfit na. Kasi hindi ba depende yan sa mga sa klase ng ating administrasyon Normally kasi a crime is committed only by individuals. Kaya lang dito sa anti-terror law, meron tinatawag na proscribed organizations Proscribed. Kaya hindi lamang individual criminal act ang pinag-uusapan dito. These are acts of an entire group or an entire organization. Kaya halimbawa, merong isang nagre-report na media practitioner. Let us say perceive lang siya as critical, no? Na bakit naman lahat ng mga nire-report mo mukhang laban sa gobyerno? Kaya lang kasi
Lagi naman may ganyan.
Oo, ang pagtingin nitong practitioner natin na ito, hindi naman ito laban, ito ang katotohanan, di ba? Bakit ba ayaw niyong makarinig ng katotohanan? Alam mo naman ng gobyerno, sensitive yan pagka tinuturo mo sa kanila yung kanilang mga mali. Di ba? Lagi silang defensive. Kaya, pagka may ganito kang klaseng batas, kagaya ng Anti-Terrorism Act na ito, 2020, gagamitin na ito. Maaari na siyang gamitin. Yun ang nakakatakot Kasi, alam mo, pwede lang sabihin, hindi. Kung hindi ka naman talaga kasama sa CPP, NPA, kung hindi ka kasama sa ISIS o hindi ka kasama sa mga terorista, hindi ka dapat matakot. Di ba? Bakit yung nagkaroon na tayo ng actual case, ano? Yung mga katutubo nating mga kapatid, kababayan natin, pinaghuhuli, kakasuhan ng Anti-Terror Act. Di ba? Ibig sabihin kahit sino. Kahit sinong maaari na talagang gamitan yan. Lalo na, yung mga galit ang gobyerno.
Malapit na yung 2022 election. Posible ba na magkakaroon ng paggamit itong batas na to para to tie the hands of dissenting parties who may want to challenge the potential heir of the current president?
Well, that is very possible kasi alam mo naman, it all depends on the creativity of those who are in power kung paano lang gagamitin yung batas. Pero mas nakikita ko dito yung mas nakikita ko dito Inda yung mga kilos ng mga maliliit na taong bayan natin. Kasi bakit sinama yung mga work stoppage? Sino ba ang nagiging involved sa work stoppage? Di ba yung mga manggagawa natin yan? Mga transport strikers natin, halimbawa, dahil naaapi sila. O yung mga nasa factory, halimbawa. Halimbawa, nag-work stoppage. Nagkaroon ng strike. Kasi yung strike is a form of work stoppage.
Yeah.
Dito sa batas na ito, pagka yan daw intended to cause death, halimbawa, meron lang isang namatay doon sa strike scene dahil nilusob ng pulis, terorista na lahat yung nag-i-strike. Kaya ang ko dito, ang aking concern, not so much yung mga kalaban ng gobyerno na ito sa politika. Kasi alam mo, factions of the elite can take care of each other Kasi may kakayahan naman sila, di ba? So kahit na magbakayan sila, maglaban-laban sila, ikulong nila yung ibang kasamahan nila na kalaban nila ngayon, that's not really the concern of mass movements. Ang concern ng mass movement, paano ba ito aapekto sa buhay ng mga ordinaryo nating mamamayan, lalong-lalo na maliliit. Kasi yun ang walang laban Hindi ba? Sino ba nagpoprotesta sa ating lipunan? Hindi ba yung mga naghihirap? Hindi ba yung mga kapos sa sweldo? Yung mga humihingi ng mas mataas sa sahod? Yung mga humihingi ng katarungan para doon sa kanilang mga sitwasyon? Ito yung mga ito yung mga lumalabas sa karsada, ito yung mga nagpapahayag, ito yung mga nag-e-exercise ng ganitong klaseng mga rights of assembly. Ito ang nakakatakot kasi sila ang isa sa mga primer na tatamaan nitong batas na ito. At what happens to political dissent? What happens to advocacy for the welfare and the rights of small people? No? Yan ang dapat nating bantayang mabuti.
Okay, one last question na lang, Attorney David.
Yes.
In a worst case scenario, and we're not going to worst case scenario lang, and it's implemented full blown. Sa tingin mo ba ang mga Pilipino will roll over and cower or do you foresee dissent?
Ganito, no? In the last few years, parang nagkaroon tayo ng pagbaba talaga ng pagkilos sa ating lipunan. And this has been aggravated by the present pandemic. Kasi ngayon, alam mo, ang mga ano sana, ang mga kilusan natin, kilusan ng mga mamamayan, ang sandata niyan yung sama-samang pagkilos, andyan ang lakas niyan Ano? Pagka may pandemic na ganito, may social distancing, hindi pwedeng gawin 'yan. Hindi magagawa. Now I think if you ask me, Inday, my own personal view, we get over the pandemic. Tapos siguro itong ating papasok na taon ng 2022 kasi mapupoliticize ang buong society natin because of the coming elections. Magkakaroon tayo ng pagkakataon na labanan ulit ng mas maigting itong batas na ito. Kung hindi man siya sentensyahan ng Korte Suprema na unconstitutional, kung hindi man siya ideklara. Kasi ako umaasa ako ng malaki, no? Although, syempre, alam mo, pagka pinag-aralan mo naman ang pattern, kasi nung panahon ni Noynoy, halos lahat ng mga kaso nila Noynoy noon sa Supreme Court talo no? Kaya nga umabot pa dun sa impeachment ni Chief Justice Corona. Pero ngayon, mukhang iba ang sitwasyon, mukhang lahat ng mga idinudulog sa Korte Suprema at pag ang kalaban mo itong rehimen ni Pangulong Duterte, medyo napakahirap talaga na makakuha ng magandang desisyon. Hindi pa natatalo si Duterte sa Korte Suprema sa aking naging obserbasyon At malaki ang posibilidad na baka hindi magpatalo dito sa punto na to. That also goes to the fact that the president is still perceived to be very popular. At saka, hindi lang siya popular, he instills fear. At itong fear na to widespread. Hindi lang ito sa taong bayan, tumatagos ito kahit na maraming lugar sa ating pamahalaan. Kaya kokonti ang tumitindig ngayon Kokonti talaga. Pag nakalusot ang batas, ang pag-asa ng taong bayan diyan, syempre mas maigting pa na paglaban. Labanan ito, i-oppose ito sa mga pamamaraan na naiintindihan natin kung paano gawin. But at the same time, pagdating ng takdang panahon, kung magkaroon ng mga mas maraming kapangyarihan ng ating mga mamamayan para mabaliktad o matanggal itong batas na ito magmula sa ating statute books na tinatawag, hari nawa mangyari yun. At baka naman agad-agad magawa natin yun. Kung hindi man sa lalong madaling panahon.
Alright, maraming salamat sa iyo, Attorney J.V. Bautista mula sa San Lakas at isang petitioner din dito sa anti-terrorism law.
Salamat po, Ed. Salamat, Inday. At salamat sa lahat ng inyong taga-subaybay.
Now, let's go back to the Supreme Court para po sa ongoing na oral arguments.
Suspect of freedom of expression. Do we have that now?
Yes, we do, Your Honor. Yes, we do.
In spite of the implementing rule?
Yes, Your Honor.
For instance?
For example, Your Honor, let's go into the subject of chilling of speech. The sword of Damocles, the damage under constitutional law is not because it falls, it's because it hangs. The passage of the law may not cause a direct harm, but the harm, for example,
Professor,
on the professors.
Professor, if I show to you a law passed in 1939, which is broader than the provisions here, but did not cause a chilling effect despite the broad provisions, would you say the chilling effect must also be something that must be clearly and convincingly shown to us? For example, I show you the provision on inciting to sedition. 1939. 1939, inciting to sedition, clearly said inciting.
Yes, sir.
Okay. Where is it? Yon, inciting. Tends to. That's even a broader provision. That's 1939. Yet, Professor, what happened in 1986?
We had a revolution, Your Honor.
And the revolution consisted of people going to the streets in mass waves. Even 1983, 84, 85, then 2000 also happened. Then many other things happened despite of this provision on inciting to sedition.
Yes, Your Honor.
The provisions are a bit broad, correct?
Yes, Your Honor.
In spite of it being in the statute books, it was not enough to chill the entire population that went to EDSA in 1986. Is that not correct?
Yes, Your Honor.
Yes. Now, you are claiming that the provisions in section 4, 5, 6, 7, 8, and 9 chills.
Yes, Your Honor.
That is your best argument to invoke Southern Hemisphere, correct?
Yes, Your Honor.
Yes. What's the difference with this provision?
Well, if we look at the sedition, which is the predicate crime of inciting to sedition, Your Honor, we know what the prohibited conduct is.
Oh, really?
We are looking
Let
at
us look
people
at-
rising tumultuously.
Excuse me,
Sorry.
Professor. Let us look at the article on sedition and see how dangerous it might be. To prevent the promulgation or execution of any law or the holding of popular election. To prevent the national government or any provincial or municipal government or any public officer thereof from freely exercising its or his function or prevent the correction of any administrative error. You know my prediction? If you were alive in 1939, you would have filed a petition with the court.
Yes, Your Honor. But I would also point to the first part.
But you see what I am aiming at?
Yes,
What
Your
I'm
Honor.
aiming at is, should there now be a sort of a limitation on what is meant by chill in terms of freedom of expression? Unless you want this court to be so powerful that in spite of some provisions in the Anti-Terrorism Act, where it tries to find a balance, regardless of how the wordings are. So for example, in section 4, subparagraph E, correct?
Yes, Your Honor.
There are provisions there which says where it will not apply, correct?
Yes, Your Honor.
And the provisions are also qualified. Is that not correct? Section E,
Yes, Your Honor.
right? So it says that the qualification in subparagraph E says that it will not apply. Next slide, please. Provided that terrorism as defined in this section shall not include advocacy, protest, dissent, stoppage of work, industrial or mass actions. My God, this is even better than the inciting to sedition provision. Don't you see, counsel?
Yes, Your Honor.
Because it carves out an exception. And the carved out exception there is advocacy, protest, dissent, stoppage of work, industrial or mass action, etc., are not included in acts of terrorism. Correct?
Yes, Your Honor.
Yes. So isn't this better?
Which actually makes it worse, Your Honor, because now you have the definition of terrorism directly covering civil and political rights, and all the prosecutor
No,
really
it's
needs
not
to
part
do
of
is
definition.
attach the last.
It says there, terrorism as defined in this section shall not include. Baka your copy did not have not.
Yes, Your Honor, but after that is except those which are not
Except
intended
which are intended
to cause death or
death.
serious physical harm.
You mean to say that we should allow protest that causes death?
Well, Your Honor, that is part of our assertion, Your Honor, that actually is the first
excuse
law
me.
that includes.
So in our sovereign guarantees that the people shall be the sovereign, we allow some people to do advocacy that causes death.
Yes, Your Honor. Brandenburg versus Ohio, which is the line of questioning by Justice
No.
Bernadette.
This one says advocacy. Doesn't say incitement. Dun tayo sa incitement section 9. For here, it's only advocacy, right?
Yes, Your Honor.
You mean to say people can cause death?
No, Your Honor.
Does
It
that
simply
not
says
restrict
advocacy, but not cause.
John Stuart Mill on liberty?
Yes, Your
You
Honor.
can
but
only have the
advocacy-
liberties for so long as you do not harm another person, correct?
Yes, Your Honor.
That's embedded into a liberal society, correct?
Yes, Your Honor.
And even I would say even a socialist one, if I may be so blunt, correct?
Yes, Your Honor.
Yes. So you mean to say that any of these exercises that causes death cannot be prevented by government?
Your Honor, the provision turns on the phrase intended. It doesn't say causes death. There's a difference, I believe, in exercising one's rights for advocacy of imminent lawless action versus something that actually causes advocacy to cause it.
So counsel, by the way, maybe let's maintain eye contact because I'm the one talking to you.
Sorry, Your Honor, I was also
Because
looking at the provision.
You were
that
always
passed.
looking at other justices. Yes.
Sorry, Your Honor.
We're the ones
Yes,
talking.
Your Honor.
Yes. Okay. Now, intended to cause death. You mean to say government cannot prevent? They have to wait until there is somebody that dies.
Oh, definitely not. That is not our
So
proposition.
that is, I think, the purpose here. You can advocate, you can exercise your civil and political rights, you can do mass action, you can even strike, you can even do stoppage of work. But when your intent is clear that you are moving towards killing somebody, government should be able to step in, correct?
Yes, Your Honor.
Yes, so can that be the interpretation of that provision?
It could be, Your Honor. It could not be, but then it devolves into vagueness because the second element of vagueness is that it leaves too much arbitrary discretion to the
Again,
enforcer.
I think we are confusing the concept of overbreadth in freedom of expression cases and void for vagueness. Void for vagueness, again, as you yourself agreed to, and you're a professor in constitutional
Yes,
law.
Your Honor.
Yes, preparing your students for the bar exam, right?
Yes, Your
Okay, now, void for vagueness means it must be applied, right?
Yes,
now,
Your Honor.
again, let's apply the test in Spark. Is there no possible interpretation at all that has been taken by government to save that?
It is our position there is none, Your
So
Honor,
you
because
are
it
again
covers
saying
advocacy and civil
that
political
government
rights.
cannot step in to stop a kind of action where the intention is to cause death upon another.
It is, Your Honor.
So when groups of people are out there calling death to Leonen, as I come out, okay, death to Leonen, and you can see that they are about to kill me, government should not step in. That is not an act of terrorism, right?
It is punishable under a different crime, Your Honor.
Under?
A different crime, Your Honor. If someone is going to kill you, Your Honor.
Yes, that one. It says intended to cause death.
Yes, Your Honor.
Yes,
but if that would be the case, then we would
Attempted
slide.
murder, frustrated murder,
Yes, Your Honor.
attempted homicide, frustrated homicide. That can be the interpretation there, correct?
Your Honor, it punishes terrorism under a different law, and therefore
You've
it
seen the
slides-
attacks on the Capitol in Washington, correct?
Yes, Your Honor.
Yes, that was a throng of people, and they were. You do not know which ones of them would want to seriously harm or cause serious death, correct?
Yes, Your Honor.
And not serious death, cause death, because any death is serious, correct?
Yes.
So therefore, you mean to say that government cannot stop that from happening?
Well, of course not, Your Honor.
Isn't that the intention there?
Well, that would be, Your Honor.
Yes.
An entire government is built on good intentions, but we really have to measure them on what the
Every
legislative
law
act
is based upon an intention.
Yes, Your Honor.
Every law is an imagined future. Every law provides for a normative statement that says this should be how it is, correct?
Yes, Your Honor.
And no language does not clearly capture everything.
Yes, Your Honor.
Yes. And whatever the intentions were in this provision, isn't it the role of the judiciary to give a chance to the political department to be able to address the harm that they wish to address before we come out immediately on a theoretical point to actually to annul that provision?
Your Honor, my humble submission is that deference, judicial restraint ends where the Bill of Rights begins.
Yes, how does that violate the Bill of Rights? It says similar exercises of civil and political rights which are intended to cause death or serious physical harm to a person, if you want to read it, looking at government as evil or demonic or with no intention at all except to do what is wrong, then you're probably right. Correct?
Yes, Your Honor.
Yes. But if you were a court of law like us, and you were trying to avoid imposing your own political convictions into an interpretation of a provision, but rather understanding that government really has to face certain kinds of terroristic acts. There was suicide bombing in Holo, correct?
Yes, Your Honor.
There were several, Marawi happened. And
Oh, yes,
in
sir.
my dissenting opinion, I called it terrorism. I did not call it rebellion. It happens, correct?
Yes, Your Honor.
In other countries, Facebook posts can cause a riot, as it did in Bangladesh or India, correct?
Yes, Your Honor.
In the
Washington.
United States, post-truth committed riots, caused riots in its own capital, correct?
Yes, Your Honor.
Yes. That is a reality which was not there in 1986, correct?
Yes, Your Honor.
Yes, and therefore now government has to meet that challenge, correct?
Yes, Your Honor.
And the role of the judiciary now is what?
Your Honor, if there is a clear conflict between the means created by government to meet a new challenge vis-a-vis the Constitution's text, the role of the judiciary is to find what the Constitution means, because it is precisely here within these four walls
But a
that
clear,
this honorable court
a
decides.
clear conflict cannot be theoretical, meaning to say we read the constitutional provision, we read the legal provision, correct? The legal provision can bear, again, Spark, can bear an interpretation which can be legitimate. Shouldn't we wait for the actual case? Maybe the Aita case is the actual case.
Your Honor,
Maybe rural missionaries is the actual case. Maybe Gabriela is the actual case. Maybe this DND accord with the UP, I don't know, might be the actual case. But we have to see how government reacts. And the only thing that we see now is the Constitution, the law, and the implementing rules and regulations.
yes, Your Honor.
Yes. And should the court now weigh in when it has not been yet? Well, it's there. It is now law of the land. Should we not wait until there is a clear case? Perhaps there can be a petition filed on those that are red tagged. And perhaps the fact should be very clear. Goes to a regional trial court first so that the regional trial court can weigh in. By the way, counsel, can regional trial courts declare unconstitutionalities of provisions?
Yes, Your Honor.
Definitely, correct?
Yes, Your Honor.
And the advantage of regional trial courts, as opposed to the Supreme Court, is that the regional trial courts can receive evidence for it to be certain of the facts that provides the ambience, that provides the context for interpreting a provision. Is that not correct?
Yes, Your Honor.
So, again, can you honestly tell us that we can step in with our power of judicial review considering all of this?
Yes, Your Honor.
Why?
Your Honor, there is already a clear conflict. There are two dimensions in this case. The civil liberties dimension, which can be met by a facial challenge even within the parameters of GeoSamar and Southern Hemisphere. And then there's a separation of powers dimension. Your Honors, the judiciary is called
I'm sorry,
the weakest
Counsel.
branch, Your Honor.
I have no idea what the dimensions you are. Can you again?
Yes, Your
explain
Honor.
this?
I may, if you may
Yes.
allow me, I can elaborate. We filed our petition thinking of not just violation of the Bill of Rights, but also violation of the separation of powers under Section 29 of the ATA.
Again, counsel, let me ask you. Congress is not concerned with the Bill of Rights.
It's concerned, of course, Your Honor.
President is not concerned about the Bill of Rights.
Oh, Your Honor, of course, our president is concerned with the Bill of Rights.
Really? You
Of
say
course,
that?
sir.
Okay, now, the Army is not concerned about the Bill of Rights.
Of course, I have to presume that our
The
armed
police
forces.
are
Yes, Your Honor.
concerned about the Bill of Rights.
Yes, Your Honor.
And interpreting any law, they will always have in mind the Bill of Rights, even if it's not written in the law, correct?
Yes, Your Honor.
So shouldn't we wait until they actually do an act that violates the Bill of Rights?
Your Honor, when the law itself is clearly against the Bill of Rights, Your Honor, then it is not for us to withhold really under expanded judicial review, Your Honor. That is our position. But we get, Your Honor, and we will certainly address the very incisive line of questioning, Your Honor, in our memorandum.
I don't think it's incisive because it's all in the genealogy of the court. This
Yes, Your
court,
Honor.
in a unanimous way, has already said that there must be a clear actual case. Yes, we have fears of any law. Yes, we have fears of any government. It's understandable. But to ask the Supreme Court to move in and use its powers without that standard would invite us to insert our own political perspective into how a law should be. I hope you understand that.
I understand completely, Your Honor, and I appreciate the line of questioning.
But because of the advice of the chief, it's 5:30. You can have 1 week to research on that point, and I will.
Yes, Your Honor.
We will call you again.
Yes, Your Honor.
We will continue Tuesday, this time at 2 o'clock in the afternoon. It will be all right. Yeah, we will start earlier. So that will be okay. So it's already 5:30. We will now adjourn the session today. Okay, let us start. Okay. Session is adjourned.
We are so pleased that leave the session hall.
And we're back live dito sa studio para po sa ating AlterMidya special coverage ng anti-terrorism law sa Supreme Court. At narinig po natin ang adjournment, no? Katatapos lamang ng session today sa Supreme Court, and they will be back next week para sa pagpapatuloy ng oral arguments. At nais po nating pasalamatan mamaya, no, ang lahat ng ating mga lawyer petitioners and guests, ng mga civil society leaders, no, dito sa ating programa. Magandang hapon ulit sa iyo, Inday.
Magandang hapon, Edge. Magandang hapon sa lahat ng nanonood, no? Very, very interesting. Ang ilang oras ba? 3 oras, no? Almost
3 oras
3 hours
mahigit.
of oral arguments. And it's only the first salvo. We're going to have a new round on Tuesday, no? Next week. Okay. So, ikaw, Edge, ano yung nakita mo? Ano yung takeaways mo, not only from the argument but also from our guests?
Isang learning session nga itong nagaganap na oral arguments. Ang dami nating natutunan from the lawyers, from the petitioners, no? Hanggang kaninang umaga, itong nangyayaring protest action, ang dami nating lessons na nakuha. Ako yung pinaka-nagustuhan kong nabanggit kanina ay yung sinabi ni Attorney Dexter Lopos, no? Na yung kapangyarihan ng mamamayan, yung supremacy ng civilian, ay yun yung mahalaga dito eh. Pero ang nangyayari, mukhang nais i-violate, no, because of an ulterior motive ng kung ano yung motive na yon, hindi pa natin alam. Possibly it's because of 2022 elections na malapit na rin, no, at alam natin na matagal na silang naghahanda for some reasons, no. Excited sila, Inday, sa elections if there will be ever an election next year. Nabanggit rin kanina, no, yung magandang punto regarding the parang may big brother na nagbabantay sa iyo because of this law. Mahalagang bantayan 'yun eh kasi parang weird, no, na meron tayong ini-enjoy natin yung civil liberties natin under a Bill of Rights. Pero ang naalala ko, I'm not a law student, pero nabanggit, di ba, there should be no law that will be passed abridging these freedoms. Pero mukhang sa anti-terror law na ito, may sabit eh. May malaking question at malaking tanong. I think yun yung mga ilang nakuha ko today, Inday.
Okay. Sige. Just a few, siguro we're just going to wrap up with a few words. It's not going to be extensive, no? But one, apparently our petitioners believe that mas malakas ang chance ngayon to challenge this law on ang tinatawag na nila a facial challenge, no? Because it's so broad that it practically affects everyone. So you don't have to say na kailangan pa ako maapektuhan kasi andyan na halos. Parang napakalawak na siya na, na almost immediately your rights are violated or threatened by the law, no? Sinasabi nga ng batas na ang advocacy naman raw ay pinapayagan, blah blah blah, except ang tawag ng mga petitioners na may fatal flaw ito. Ito yung pagpasok na inclusion of intention, no? This is intention to cause deaths, endanger public safety, etc., as grounds for designation of a person or an organization as terrorist. Ngayon, paano nga raw ba how can a small group determine intention and then act on it without having to go to the courts? Yun ang contention talaga ng petitioners. And having acted on it, threatened the human rights and civil liberties of people, but so drastically, 24, at least up to 24 days, no, na incommunicado ka, may freezing of assets and everything, and it can keep on going, it can keep on and on, no. Ang sabi na banggit mo, pwede ba itong gamitin sa 2022? Yes, pero may magandang punto si Attorney J.V. Bautista at actually si Teddy si Teddy
Teddy Casino.
Casino rin kanino, no? Ang sabi nila, hindi pa politiko eh. Yung maliliit na mga tao, no? Yung ordinary citizens, workers, farmers, indigenous people who may be accused of having in nefarious intentions by the Anti-Terrorism Council. At kapag sila ay napasok sa lista, napakaliit ng kanilang rekurso, no, sa legal redress para sa nangyayari, no. Lalo na dahil kinuha na yung dating compensation for those unjustly accused and unjustly jailed in terms of terrorism, no. Maaring ang pinaka-high profile na enemies of the state, di umano, ay mga organized activists and political actors and certainly feeling the heat these days. But this covers everybody, no? And naibanggit mo rin ang free expression, as sinabi rin kanina, is that those who cover, those who report on advocacy groups that are designated as terrorists could find ourselves also into trouble, no? When we insist on the people's right to know and insist on still covering these groups and their leaders and members of it, no? Sari-sari, napakarami, pero siguro ang maitatanong natin is bakit ngayon, no? Ganito na lang. 4 na taon na tayo nakaharap sa isang gobyerno kung saan the entire concept of due process ay tinapak-tapakan, no? Tinadtad, no? Tinapon, no? Gutay-gutay na ang ating konsepto na due process na napakataas na sinasaad ng konstitusyon. So hindi nakakagulat na from that, precisely sa drug war, ay inexpand nila sa halos lahat ng posibleng tatamaan. Sabi nga hindi komunista, hindi terorista, halos lahat na ng posibleng pwedeng mag-defy sa gobyerno on any grounds and any ground ay posibleng tatamaan nito. Ang suma totalan dito, sabi nga natin, is once a law this broad this draconian, this cruel to citizens' rights is allowed to triumph over this country. Hindi kailangan ng martial law. Babagsak ang dilim, bubusalan lahat. Kasi the alternative, the price of speaking out, the price of fighting for your rights, the price of fighting for other people's rights is going to be so terrible. Ang sabi ko nga kanina, chilling will be an understatement. Sana magtagumpay ang mga petisyon and sana hindi matinag ang taong bayan, no, sa pagtayo at pagsulong ng karapatang pantao. Na galing na tayo sa madilim na panahon, wag nating hayaang magwagi ang kadiliman ulit. Edge?
And for that, Inday, pasalamatan natin lahat ng ating mga panauhin kanina, ang ating mga guests. Please allow me to thank Sister Mary John Manansan ng Movement Against Tyranny, dating kinatawan ng Bayan Muna, Representative Teddy Casino, mula rin sa Movement Against Tyranny. Nakausap rin natin si Attorney VJ Topacio mula po sa CTU-HR Petition. Attorney Dexter Lopos ng Union of People's Lawyers in Mindanao at si Attorney JV Bautista mula po sa San Lakas. Maraming salamat po sa inyong pagbahagi ng inyong mga kuro-kuro. Inday?
Salamat sa pagtutok sa AlterMidya special coverage ng oral arguments sa Supreme Court. Muli ito si Inday Espina Barona.
At Edgy Uyanggoren.
Magandang hapon, magandang gabi sa ating lahat.
Magandang gabi po sa inyong lahat. Yay! Makakahiga na ako.
Salamat, Edge. Nangati na yung lalamunan ko, haba!
May video ba?
Nangati na lalamunan ko dun
Sa ilang parts ka parang mamimil tapos hindi mo kita yun. Natatanga eh. Thank you, thank you.
Galing ni Edge, grabe!
Yeah.
Thank you. Bye-bye.